Professor Emeritus, University of the Philippines School of Economics, Attorney Florencio B. Abad, Professor of Praxis, Ateneo School of Government, Honorable Franklin M. Dirod, former President of the Senate of the Philippines, and Honorable Benjamin E. Jokno, Member, Monetary Board, Bangko Sentral ng Pilipinas. Thank you very much. As discussed during the preliminary conference conducted last February 4, 2026, and as is stated in the advisory dated February 18, 2026, the parties shall be heard in the following manner. 1. Counsel for petitioners in the consolidated petitions will be heard jointly for 30 minutes. 2. Counsel for the respondents shall be heard immediately after the completion of counsels for petitioners' argument. They shall also have a total of 30 minutes to present their arguments. The time allotted for a counsel to argue shall be exclusive of the time devoted to interpellation by the members of the court. The interpellation of the members of the court will immediately follow after both parties complete the presentation of their arguments. The Council of Petitioners may now approach the podium for their presentation.
The Honorable Chief Justice, Senior Associate Justice, and the Associate Justices of the Supreme Court, good day. I'm Attorney Vopetro Angie Peña. I will be addressing the procedural issue and 4 substantive issues, namely whether unprogrammed appropriations violate Section 22, Article 7, requiring the budget to have sources of financing, whether unprogrammed appropriations are rider provisions, and whether unprogrammed appropriations violate the separation of powers and the effect and undue delegation of legislative power. On the sole procedural issue, petitioners respectfully submit that a temporary restraining order must issue enjoining the implementation of Section 43 of RA 12314 or the General Appropriations Act of 2026. Petitioners possess a clear and unmistakable right as citizen taxpayers to ensure that public funds are appropriated and disbursed strictly in accordance with the Constitution. Your Honors, the unprogrammed appropriations create a contingent pool of funds that circumvents the constitutional design of the Constitution and appropriations. It also violates the separation of powers and affects an undue delegation of legislative power. By conditioning release of funds on future events, Congress cedes to the executive the authority to determine when unprogrammed appropriations take effect. This is impermissible post-enactment discretion as prescribed in Belgica versus Ochoa, and it also a clear violation of the separation of powers as affirmed in Arroyo versus Aquino. When fiscal measures erode constitutional boundaries, judicial intervention is imperative. This court in Belgica enjoined the release of PDAF funds to prevent unconstitutional disbursement. This court as well in Pimentel issued a TRO against the transfer of PhilHealth funds and the implementation of constitutional rider in Special Provision 1D under unprogrammed appropriations. In both instances, the court preserved the status quo and prevented the irreversible expenditure of public funds pending judicial review. The same necessity is present here because of the constitutional infirmities in the unprogrammed appropriations. For most, unprogrammed appropriations constitute a rider. The Constitution requires that every provision in the GAA must be germane to a particular appropriation. The President himself recognized that the national budget is 6.793 trillion, corresponding only to programmed appropriations, thereby confirming that the unprogrammed appropriations stand apart from the GAA. Not being related to a particular appropriation, it violates Article 7, Section 22 of the Constitution. As underscored in our earlier, Your Honors, public funds may be disbursed only pursuant to a valid appropriation supported by law. Section 43 identifies no concrete funding source. It relies instead on conditions, excess revenues, new revenues, or loan proceeds. These are not sources of funding, but mere contingencies upon which funding may arise. The President acknowledged in his veto message that releases from the unprogrammed appropriations will still require specification of funding source. This confirms that at the time of enactment, there is no funding base for the revised AFP modernization program, the program for risk management, and the support to foreign-assisted projects. Without a funding base, there is no valid appropriation. Respondents characterize these items as standby appropriation. But Your Honors, the Constitution has only one mechanism for contingent spending: special appropriations, wherein Congress itself determines at a proper time whether additional expenditures are warranted. The structure of the UA also violates the non-delegation doctrine. Here, the power to determine when unprogrammed appropriations take effect is left entirely to the executive. The executive thus decides not only how to implement the law, but also when it takes effect. The President acknowledged the availability of supplemental appropriations, yet allowed the unprogrammed appropriations to stand. Your Honors, constitutional compliance cannot yield to convenience, practice, or concurrence between political branches. The injury is also actual and imminent. The provision authorizes the release of funds at any time, exposing public funds to immediate unconstitutional disbursement. Once released, they are permanently spent, causing grave and irreparable injury. This honorable court must declare unprogrammed appropriations as unconstitutional to reaffirm that only Congress wields the power of the purse, that appropriations rest on ascertainable funding, and that all public spending must be done within the strict bounds the Constitution commands. Your Honors, if the unprogrammed appropriations are not blank checks, they are checks drawn against insufficient funds, issued not by the people through Congress, but by the executive. These checks must be voided before they are even honored and drawn against the account of the Filipino people. I end my presentation here. I will cede the podium, Your Honors, to my co-counsel. Thank you, Your Honor, for your time and indulgence. May it please
Thank
the
you.
court.
Thank you.
I have a presentation, Your Honor, just a short one.
Tatlong kainan, kasi po hindi talaga kasya kahit anong pilit mong bakit na hindi talaga sa magluto pa man, wala, hindi ka kasya ninyo.
Dati pinapagas ko lang 900, ngayon pinakita mo ng loading. Ano mo may uwi mo?
Hindi siya kakasya, definitely. Imposible.
All in all, average family income of low-income families is about 25 to 30,000 a month. Even at that level, we're discovering that that's not enough to cover food, education expenses, health plan expenses for a family of 5.
Mga sa isang ikon, magulang ka sa pag-usel.
Hindi pa tumatas yung sahod. Wala na, binabudget na lang namin. Kunti na lang. Bibili para makaraos lang. Magtipid na lang. Hindi na tayo kakain.
May limit ang bawat pamilya. Dapat pumeso, ganun din sana.
Notice, when we use colloquially budget, it means negative. When our supposed representatives use it, it adds. And at whose expense? I asked the court to picture an ordinary Filipino family at their kitchen table. At night, a father places his day's wages on the table, and a mother opens a worn notebook to carefully divide what little they have: rice, tuition, medicine, transportation. Every peso is assigned. Every choice has a consequence. For that family, the budget is a hard limit, not predicted. When money runs out, spending stops. Multiply that limit to the rest of Filipinos, and you have the discipline of a nation. Last time I checked, this nation is a representative democracy. Why then are our representatives doing everything in their power to not represent that discipline? In Republic Act number 11975, the 2024 General Appropriations Act, that discipline was set aside. Instead of a fixed and accountable budget, what was created is a system where spending may expand, shift, and be triggered after the law has already been enacted, without the full safeguards required by the Constitution. At the core of this case are three questions. First, whether program appropriations violate Section 25(4) of Article 6. Second, whether Congress may increase these appropriations beyond what the President proposed. And third, whether Congress may enact new programs, activities, and projects. These questions may appear technical, but they all point to a single principle. The Constitution requires discipline, clarity, accountability in the use of public funds. On the first issue, Section 25(4) of the Constitution requires that any special appropriations bill state the purpose and be supported by funds actually available as certified by the National Treasurer, or be matched with a corresponding revenue proposal. These are not mere technicalities. They are safeguards designed to prevent abuse and to ensure that the government cannot simply move money around at will. However, program appropriations do not comply with these requirements. They become usable only later when certain conditions are met, are not funded at the time the law is passed, and in relation to Section 25(5), do not depend on savings. In the 2024 GAA, these conditions were even expanded to include, among others, the use of government-owned or controlled corporations' fund balances. This means that spending authority can arise after the budget has already been approved. That is not transfer of funds within constitutional limits. It is in substance the creation of a new appropriation after the enactment. When spending authority exists without savings, without definite appropriation at the outset, and without safeguards required by the Constitution, Section 25(4) is not being followed. It is being bypassed. On the second issue, the Constitution is equally clear. Congress may not increase the appropriations recommended by the President. This rule ensures fiscal discipline by requiring that the national budget be anchored on the executive's projections of revenues and expenditures. The President's proposal reflects a coherent fiscal plan based on actual economic realities. Yet in this case, Congress expanded on program appropriations far beyond what was recommended. What was originally limited to 8 purposes was enacted to 51 purposes. transforming a narrow standby mechanism into a broad and flexible source of spending authority. Even if the total figures may appear similar at first glance, the Constitution is not concerned only with arithmetic totals, but with the power those figures represent. By expanding the purposes, the triggers, and the flexibility of these appropriations, Congress effectively increased the government's authority to spend. This is a functional increase, one that achieves indirectly what the Constitution expressly prohibits directly. If this is allowed, the prohibition in Section 25(1) becomes meaningless, as Congress could always bypass it simply by labeling appropriations as conditional rather than actual. On the third issue, the reclassification of programs, activities, and projects between programmed and unprogrammed appropriations further undermines constitutional safeguards. A programmed appropriation is funded, definite, and ready for implementation, while an unprogrammed appropriation is contingent and uncertain. Allowing movement between these categories changes the natures of the appropriation itself. A project that was certain becomes uncertain, and one that was conditional may later be treated as funded, all without passing a new law. This is not merely an administrative adjustment. It is, in effect, a rewriting of the budget after it has already been approved. Such mechanism defeats the requirement of specificity, weakens accountability by deferring decisions to post-enactment processes, and blurs the separation of powers by shifting fiscal decision-making away from Congress at the time of legislation. Ultimately, what emerges from these mechanisms is a system that the Constitution does not recognize. A shadow budget that is contingent, expandable, and dependent on discretion after enactment. Public funds belong to the people, and their use must be governed by clear constitutional limits, not by shifting conditions or post-enactment authority. If an ordinary Filipino family must live within its limits, then our representatives must live within the Constitution. Thank you, Your Honors.
Thank you.
May it please the court. I'm Attorney Joseph Lemel Bakiran, Your Honor, respectfully appearing as counsel for petitioner FPJPM. For the petitioner's FPJPM, Your Honor, we are assigned two topics. That is, whether the legislative branch may validly increase the amount of special accounts in the general fund recommended by the executive branch. And the second one is whether the legislative branch validly increase the earmarked funds for the road users fund by reallocating items in the 2025 General Appropriations Act. Your Honors, this petition raises constitutional question of the highest importance. Whether Congress, through the bicameral conference committee, may increase appropriations beyond those recommended by the President in violation of Article 6, Section 25, Paragraph 1 of the Constitution. At stake, Your Honors, is not merely a difference in figures. What is at stake is the constitutional boundary between the executive initiative and legislative authority and the integrity of the national budget process itself. Your Honors, the facts are undisputed. The President submitted the 2025 National Expenditure Program with a total expenditure level of 6.352 trillion, including 27.352 billion in special accounts in the general fund. These special accounts in the general fund form part of automatic appropriations, funds governed by law, sourced from earmarked revenues, and intended to operate with limited legislative discretion. Among this is the Special Road Fund, sourced from motor vehicles users charged under Republic Act 8794, as amended, strictly tied to actual collections and specific statutory issues. However, Your Honors, during the bicameral deliberations, Congress introduced substantial increases. The special accounts in the general fund was increased from 27.352 billion to 40.107 billion. The special road fund was increased from 16.756 billion to a staggering 34.748 billion, or an amount of 17.992 billion, Your Honors. These are not minor adjustments. These are structural expansion of the budget. This brings us to the first issue, whether Congress may increase appropriations beyond the President's proposal. The Constitution is unequivocal. Article 6, Section 25(1) expressly prohibits Congress from increasing the appropriations recommended by the President. Congress may reduce, may realign, or modify, but it may not increase. Yet here, Your Honors, the Bicameral Conference Committee did precisely what the Constitution forbids. By increasing the special accounts in the general fund, an automatic appropriation, Congress expanded the total expenditure program beyond the President's proposed ceiling. This is not amendment. This is unconstitutional expansion. The violation becomes more pronounced when the nature of these funds is considered. Special accounts in the general fund are not ordinary appropriations. They are funded by earmarked revenues. They are governed by specific statutes. And they are automatically appropriated based on available income. In short, they are revenue-bound and self-executing. Yet Congress increased these funds without any corresponding increase in earmarked revenues. This breaks a fundamental rule that special funds may only be spent to the extent of what is actually collected or authorized by law. This leads to the second issue, whether Congress gravely abused its discretion in increasing the special road fund beyond its lawful limits. The special road fund is clear in both law and structure. It is funded exclusively by the motor vehicles users charge and may only be programmed within actual or projected collections. But here, Your Honors, the additional 17.992 billion did not come from the motor vehicle users' collections. It came from pooled funds and general budgetary sources. Your Honors, this is constitutionally untenable. Because once a fund is detached from its earmarked source, it ceases to be a special fund. It becomes an unauthorized appropriation, merely labeled as one. Taken together, these acts reveal a clear pattern of unconstitutional overreach. First, by increasing appropriations beyond the President's proposal, and second, by detaching special funds from the statutory revenue sources. Both acts produce the same result, an unauthorized expansion of the national budget. Your Honors, this case is not about policy. It is not about whether these expenditures are beneficial. It is about whether constitutional limits still bind the political branches. And if these actions are allowed to stand, Your Honors, then the prohibition in Article 6, Section 25(1) becomes illusory. The Bicameral Conference Committee would effectively acquire the power not merely to reconcile, but rewrite the national budget. And the constitutional balance between the executive and legislative branches would be fundamentally altered. In closing, Your Honors, the Constitution entrusts this most honorable court with the duty to enforce the limits of power, especially in matters of public spending. Because when those limits are ignored, what is placed at risk is not only fiscal discipline, but the rule of law itself. For these reasons, petitioners respectfully pray that the said provisions of the 2025 General Appropriations Act be declared unconstitutional and that the acts of the Bicameral Conference Committee be struck down for grave abuse of discretion. Thank you, Your Honors.
Thank you.
The Honorable Justices of the Supreme Court, good morning, Your Honors. I am Attorney Elmar Barreda, and this representation, Your Honors, please, will argue on the following substantive issues, Your Honor, please. Number one, whether the legislative branch may validly increase any appropriation recommended by the executive branch. Number two, whether the legislative branch may validly move programs, activities, or projects, PAPs, from the program appropriations to unprogrammed appropriations and vice versa. Third, whether the Congress may make new PAPs not found in the National Expenditure Program. Your Honors, please, let me proceed. It is argued that the legislative branch may validly increase any appropriation recommended by the executive branch, may not validly increase any appropriation recommended by the executive branch. To support these arguments, Your Honor, the law prohibiting the legislative branch from increasing any appropriation recommended by the executive branch is Section 25, subsection 1 of Article 6 of the 1987 Constitution, unequivocally stating that the Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. Section 25, subsection 1 of Article 6 of the 1987 Constitution is a limitation imposed upon the Congress not to increase the appropriations recommended by the President for the operation of the government as specified in the budget. The text of the petition in GR number 271059, as formulated by the petitioners Edsel Silagman and Mujib S. Hataman, is that this limitation is absolute, where the Congress is without any discretion to increase the President's recommendation in the National Expenditures Program, or the NEP. The phrase as specified in the budget in Section 25, subsection 1 of Article 6 of the 1987 Constitution defines the subject appropriations that the legislative branch may not increase. In other words, the ban on the increase applies to any kind of appropriation so long as it is specified in the budget. This point is important because the subject constitutional provision made no mention the collective words program appropriations and unprogrammed appropriations. To denote two different kinds of appropriations, one between the two, which is the unprogrammed appropriations, is the subject of the petition in GR number 271059, insofar as the excess amount from the President recommended budget in the NEP. Specifically, in GR number 271059, seeks to vanquish in the 2024 General Appropriations Act, or RA 11975, the amount of 449.5 billion, representing the excess from the amount of 289.1 billion in unprogrammed appropriations the President recommended. Notably, the excess amount of 449.5 billion in the unprogrammed appropriations is not supported by the recommendation of the President, is greater than the amount of 289.1 billion supported by the recommendation of the President. Section 25, subsection 1 of Article 6 of the 1987 Constitution should be read in conjunction with Section 22, Article 7 of the 1987 Constitution, stating that the President shall submit to the Congress within 30 days from the opening of every regular session as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from all existing and proposed revenue measures. Clear in the Constitution, Your Honors, please, that the General Appropriations Bill must be based on the budget of expenditures submitted by the President to the Congress. In other words, the President's National Expenditures Program is the legal foundation of the Congress General Appropriations Bill. Thus, appropriations beyond or outside what the President recommended is without basis as required under Section 22, Article 7 of the 1987 Constitution. Clearly, in GR number 271059, the excess amount of 449.5 billion in the unprogrammed appropriations is without constitutional basis, not being covered by the President's recommendations, capped only at 289.1 billion. Thus, as prayed for by the petitioners Edsel C. Lagman and Mujib S. Hataman in their petition, the challenge excess of 449.5 billion should be nullified in the 2024 General Appropriations Act. Without noting any bad faith on the part of the executive branch in the preparation of the annual budget for 2024, the heads of agencies and departments of the national government and the President enjoy the presumption of regularity in the performance of official duties. Thus, budget documents they formulated should not have been disturbed by the Congress by increasing the unprogrammed appropriations in the 2024 General Appropriations Act, or RA 11975. Moving forward to the next assigned issue, Your Honors, please. It is argued that the legislative branch may not validly move programs, activities, or projects from program appropriations to unprogrammed appropriations, and vice versa. Notably, when this Honorable Supreme Court promulgated on December 3, 2025, its decision in consolidated GR numbers 274778, 275405, and 276233 in their separate concurring or dissenting opinions, three honorable justices opined about this legal issue as follows. First, the Honorable Senior Associate Justice Marvic Leonen stated that the national budget originates from the executive department. Each department or agency can already determine what the potential expenses are for the coming years, including miscellaneous expenses. Thus, it is already anticipated. It is not right to transfer them to unprogrammed appropriations. Second, Your Honors, please. Honorable Associate Justice Alfredo Benjamin S. Caguiwa stated that in sum, I respectfully submit that moving PAPs from the program to unprogrammed appropriations violate the principle of separation of powers based on the following grounds. First, Congress encroached on the budget preparation phase by arrogating unto itself the function of prioritization of programs for the implementation of the executive vis-a-vis the allocation of available funds. Second, the Congress exceeded its power to appropriate when it increased the total appropriations by inserting new PAPs. Third, Honorable Associate Justice Ramon Paul Hernando stated that unprogrammed appropriations in any form are unconstitutional. It is submitted that the opinions mentioned are the most recent and relevant to support the argument that the legislative branch may not validly move programs, activities, or projects from the program appropriations to unprogrammed appropriations and vice versa. There is no cogent reason that this opinion should not be adopted as well as by this Honorable Supreme Court in the resolution of the legal questions involved in the present petition. Going to the last assigned issue, Your Honor, it is argued that the Congress may not make new PAPs not found in the National Expenditure Program. If the Congress may not increase any appropriations recommended by the executive branch, as the same will have no basis pursuant to Section 25, subsection paragraph 1 of Article 6, in conjunction with Section 22, Article 7 of the 1987 Constitution, as earlier argued. Logically, the Congress may also not make new programs, activities, or projects not found in the National Expenditure Programs, because the same will also no legal basis under the same constitutional provision. Likewise, as opined by the Honorable Associate Justice Alfredo Benjamin S. Caguiwa, Congress exceeded its power to appropriate when it increased the total appropriations by inserting new PAPs. In doing so, the Congress committed grave abuse of discretion amounting to lack or excess of jurisdiction, justifying once again the need for this Honorable Supreme Court to exercise its expanded power of judicial review. The worst instance of grave abuse of discretion is a blatant violation of the 1987 Constitution, Your Honors. In closing, Your Honors, please, it is most respectfully implored of this Honorable Supreme Court to grant the petition of Edsel C. Lagman and Mujib S. Hataman to nullify by declaring unconstitutional the excess of 449.5 billion in unprogrammed appropriations in the 2024 General Appropriations Act, or RA 11975, in GR number 271059. Thank you very much, Your Honors, please.
Thank you. The Solicitor General may proceed to the podium for her presentation. Please proceed, sorry. Sino siya?
May it please the Honorable Court, once again, Your Honors, good day. I am Bianca Isabel D. Soriano, appearing for petitioners Teresa and Medina. On issue number 2E, whether the legislative branch may validly create new programs, activities, or projects or PAPs not found in the National Expenditure Program or the NEP, petitioners for GR number 04036 is of the affirmative position, but within its defined constitutional limits. Your Honors, this case is not about expanding nor diminishing the Congress's power of the purse. It is about preserving that power within its constitutional design. As early as the 1994 case of Phil Consa versus Enriquez, this honorable court held that while the President may propose the budget, the final say on appropriations in the matter is lodged in Congress. Thus, the legislative branch is not confined in the NEP. It may amend, adjust, and even introduce new PAPs. But to clarify, Your Honors, that authority is not unbounded. First, under Section 25.1, Article 6 of the Constitution, Congress may not increase the total appropriations beyond the amount proposed by the President. The President proposal thus operates as a fiscal ceiling, ensuring discipline in public spending. Second, jurisprudence teaches that appropriations must be specific, definite, and for a particular public purpose. Safeguards that ensure accountability in the use of public funds. These are not mere formalities, they are constitutional safeguards that define the limits of legislative power. In sum, Your Honors, for petitioners in GR number 04036, the legislative branch may create new PAPs not found in the NEP, as long as it respects the constitutional ceiling and adheres to the safeguards to discipline the use of public funds. Anything less would diminish Congress's role. Anything more would distort the Constitution. Thank you, Your Honors, and may it please the Honorable Court.
Thank you. The Solicitor General, please proceed with your presentation.
Chief Justices Mundo, Senior Associate Justice Leonen, Associate Justices of the Supreme Court and Bank. I am Solicitor General Darlene Marie B. Berberabe, and with me are the Assistant Solicitors General and Solicitors. Ano ang akma at makatarungang budget? Kung tatanungin ang magsasaka, manggagawa, guro, ang isang ina, marahil ito ang sagot. Isang budget na tumutugon sa kanilang mga pangangailangan, pagkain sa hapag, edukasyon para sa mga anak, maayos na kalsada, ospital na mapapagdalhan ng may sakit, at trabaho para matustusan ang pangangailangan ng pamilya. Ang bawat isang nagbabayad ng buwis ay umaasa na ito ay ilalaan para sa kanila ng tama, maayos at buong katapatan. That is the national budget that each government works towards. And the 1987 Constitution provides the framework to make that happen. It assigns to the executive and the legislature a specific, defined role in the budget process. The Constitution recognizes that a responsive budget requires both the executive's knowledge of government capacity and resources and the legislature's understanding of what the people actually need. This is the meaning of separation of powers, that government authority is divided among three branches: legislative, executive, and judicial, so that no single branch becomes too powerful. Each branch has its own role, and the Constitution itself prescribes the mechanisms to ensure the balance of power as well as accountability. The executive handles administration, the legislature enacts, the judiciary interprets the law, each branch in its lane, each branch doing its constitutional duty. Some issues are intended to be left to the political branches of the government. In our jurisdiction, the determination of whether an issue involves a truly political and non-justiciable question lies in the answer to the question whether there are constitutionally imposed limits on the powers or functions conferred upon political bodies. If there are, and a petition is lodged before the court, then our courts are duty-bound to examine whether the branch or instrumentality of the government properly acted within such limits. This is what we hope to thresh out today, whether in passing the General Appropriations Act of 2024, 2025, and 2026, the executive and legislative exercise their power within the limits imposed by the Constitution. The Constitution assigns to the executive the task of planning the budget. Under Article 7, Section 22, the President must submit to Congress a budget of expenditures and sources of financing. This is a plan prepared by the executive, a plan grounded in what the government can realistically accomplish and what the country can afford. The President, through the DBM and the economic managers of government, is best positioned to know the condition of public finances, the capacity of implementing agencies, and more importantly, the realistic projections for revenue. The President's proposed budget is based on that knowledge. The Constitution assigns Congress the task of deliberating on behalf of the people. Senators and representatives are elected to represent their constituents' needs. They are in the best position to know what roads are required and where they must be built, what hospitals are lacking, which communities need classrooms. Congress holds hearings, questions cabinet secretaries, studies and debates priorities before it enacts the budget. Congress is constitutionally given the power of the purse. The Constitution assigns this honorable court the task of determining, when properly petitioned, whether Congress and the executive have exercised the power that the Constitution has assigned to each. In exercising this power, the court does not pass upon the wisdom, necessity, or policy choices made by the legislature in enacting the GAA. These are matters within the exclusive domain of Congress. Rather, the court's review is narrowly confined to questions of constitutionality, of whether the constitutional limits have been breached. It may examine whether the GAA complies with constitutional requirements, such as single correspondence rule, the prohibition against riders, the requirement that appropriations be for public purpose. It may also strike down provisions that unduly delegate legislative power or infringe upon the powers of other branches. It is only upon a clear showing of violation of constitutional rules or of grave abuse of discretion by its co-equal branches that the court's power of review is triggered. This is important to preserve institutional independence and mutual respect. In Arroyo versus De Venecia, this court, with its wisdom and disciplined regard for constitutional boundaries, said that in passing upon the validity of legislative acts, the court acts with caution and restraint, for there is always the danger that in the exercise of judicial power, it may be taken as engaging in the usurpation of the power of legislation. The legislative process, including the passage of the GAA, carries the presumption of constitutionality. The enrolled and authenticated bill, signed by the presiding officers of both houses, is evidence of its due enactment. According to Arroyo, in the absence of evidence to the contrary, the court will respect the certification of the presiding officers of both houses that a bill has been duly passed. Kagalang-galang na mga mahistrado, pahintulutan po ninyong mailahad ko ang kaibuturan ng usapin ngayon. Ano ba itong unprogrammed appropriations? Ito ba ay lumalabag sa konstitusyon? May nilabag ba sa konstitusyon ang dalawang sangay ng gobyerno nang ipinasa ang GAA ng 2024, 2025, 2026? Ipinagbabawal ba ng saligang batas ang paghahanda ng listahan ng mga programa na ang pagkukunan ng pondo ay kakaiba sa pondong pagkukunan ng mga programang may prioridad? In their simple form, these are the questions raised against the constitutionality of unprogrammed appropriations. Before addressing the constitutional questions directly, allow me to explain what unprogrammed appropriations actually are. Petitioners' characterizations of them as blank checks and shadow budgets are politically agitating, however, they are incorrect. Let me use an analogy. Kapag nagpaplano ang isang pamilya ng kanilang budget, sila ay nagkikwenta kung magkano ang pondo ng pamilya, magkano ang kinikita ni nanay, ni tatay, at lahat ng pagkukunan ng pera ng buong mag-anak. Pagkatapos, maglilista, ano-ano ba ang pagkakagastahan? Bahay, pagkain, pamasahe. Pagkatapos nito ay ililista rin magkano ang bawat isang pagkakagastusan. So may dalawang kategorya sa budget ng pamilya. Una, ang mga pangunahing pangangailangan ay dapat mapaglaanan ng pera. Ang pagkain, upa sa bahay, tuition fee, kuryente, pamasahe. Pipiliin ng magulang kung alin ang kinakailangan para mairaos ang disenteng pamumuhay araw-araw. Subalit, maganda rin sana na may mailaan para sa pagpapagawa ng bubong, makabili ng laptop, makapasyal sa park, makabili ng motorsiklo. Ito ang pangalawang kategorya. Ito ay mga kailangan din para mas umangat ang kalidad ng buhay. Magandang maisama na rin sa plano dahil pwede naman magtinda ng lutong bahay pandagdag kita o kaya naman may bonus na matatanggap sa trabaho si nanay o magkaumento sa sahod si tatay. Kahalintulad nito ang programmed at unprogrammed appropriations. Ang programmed ay ang prioridad na pagkakagastusan. May kabangga itong pagkukunan ng pera na mas tiyak at nakaplano ng darating. Samantalang ang unprogrammed ay yung mahalaga ring mapaglaanan ng pera dahil sa ikabubuti rin naman ito ng pamilya, pero ang pagkukunan ng pera ay hindi pa tiyak pero may basihan. In every Filipino household and in every budget, there are needs that must be met no matter what. There are also aspirational needs which, while important to improve the quality of life, can only be met if and when money becomes available. The government, like every Filipino family, plans for both. Your Honors, unprogrammed appropriations are the government's aspirational priorities, programs which are also needed and ready for implementation, but whose funding depends on specific fiscal events that may or may not occur. Their funding sources, as determined by Congress, consist of first, non-tax revenue collections that exceed government targets. Second, new revenue collections from new tax or non-tax sources. Or third, proceeds from approved loans for foreign-assisted projects. The purposes for which unprogrammed appropriations are passed are not secret. They are legislated and publicly available. If none of the triggering events happens, not a single centavo may be released. Before any peso can move, a fiscal condition must be met. The Bureau of Treasury must certify it. The DBM must issue an allotment, and the implementing agency must submit a special budget request. Only then may DBM issue a special allotment release order. These are specific steps that the executive branch takes in order to comply with the clear targets set by the legislature. The unprogrammed appropriations are neither a blank check nor unconditional. They are among the most conditioned and controlled spending authorizations in the entire government system. Unprogrammed appropriations give the government fiscal flexibility. They ensure that a windfall does not go undeployed while public needs go unmet, without requiring anew a full deliberative cycle of a special appropriations bill which duplicates effort and takes time to pass. Since the 1987 Constitution, across administrations, from President Cory Aquino in 1989 to Presidents Ramos, Estrada, Arroyo, Aquino, Duterte, and now President Marcos, unprogrammed appropriations have been a standard and relied upon feature of the national budget year after year. This long history manifests consistent, contemporaneous constitutional construction by the court's co-equal branches, which should not be taken lightly. As this court, aptly stated in KMU versus Aquino, a parameter of judicial review is determining who can read the Constitution. Interpreting its text has never been within the exclusive power or province of the courts. Other branches of government are equally able to provide their own interpretation of the provisions of our organic law, especially on the powers conferred by the Constitution and those delegated by Congress. More importantly, the constitutionality of unprogrammed appropriations has already been ruled upon by the Honorable Court. In Araulio versus Aquino in 2014, the court recognized unprogrammed funds as a legitimate source of government financing, subject to their specific trigger conditions, and applied those conditions in assessing the legality of disbursements under the Disbursement Acceleration Program. And in Belgica versus Executive Secretary in 2019, the court ruled explicitly and categorically the appropriation for the unprogrammed fund is constitutional. It has a clearly discernible singular appropriation purpose. It complies with the rule on singular correspondence. It is not a prohibited lump sum fund. It does not constitute an unconstitutional post-enactment legislative intrusion. The petitioners asked this court to overrule Belgica 2019, but they have not presented a single compelling reason, whether factual or doctrinal, in support of their challenge. Without having discharged their burden, petitioners' constitutional challenge should not be allowed to stand. Mr. Chief Justice, honorable members of the court, allow me at this point to directly address some constitutional questions as identified by the court's advisory. First, do unprogrammed appropriations violate Section 22, Article 7 of the Constitution? The answer is no. Article 7, Section 22 requires the President to submit a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. The President did precisely that. The ERISE petition argues that the sources must be actually existing at the time of the submission of the proposed budget by the President and when the GAA is enacted. But Section 22 does not require this. What it requires is for the budget to be based on existing and proposed revenue measures, meaning the revenue sources must be identifiable and real, not speculative. A budget based on revenue programs is fully consistent with Section 22's mandate. Second, do unprogrammed appropriations violate Section 25 for Article 6? The answer is no. By its express terms, Section 25, Number 4, Article 6 of the 1987 Constitution merely applies to special appropriations bill, not to general appropriations bills. It requires that a special appropriations bill be accompanied either by 1, a certification of availability of funds issued by the National Treasurer, or 2, a corresponding revenue proposal where funding is not yet available. Unprogrammed appropriations, however, form part of the GAB. Accordingly, Section 25, Number 4, Article 6 of the 1987 Constitution does not govern their inclusion in the GAA. Third, are unprogrammed appropriations rider provisions that violate Section 25, Number 2, Article 6? Again, the answer is no. Unprogrammed appropriations are not foreign to the GAA's purpose. Belgica 2019 already held that they have a clearly discernible singular appropriation purpose. A provision that has a discernible appropriation purpose cannot simultaneously be a rider lacking germane purpose. In Atitiu versus Zamora, the court, recognizing that an appropriations bill covers a broader range of subject matter and includes more details compared to an ordinary bill, stated that its provision is germane, if particular, unambiguous, and appropriate. Given their specified purposes, defined amounts, and explicit conditions, unprogrammed appropriations meet this standard. Fourth is the rule which prevents Congress from exceeding the budget ceiling proposed by the President violated when unprogrammed appropriations are enacted or when Congress increases their specific sums. Again, no. As Commissioner Davide explained in the Constitutional Commission deliberations, the purpose of the prohibition imposed by Section 25, Number 1, Article 6 is fiscal discipline. It prevents Congress from authorizing programmed expenditures that would exceed projected revenues and produce a budget deficit. Unprogrammed appropriations cannot produce that effect because the sources of funds are different from the sources of funds of the programmed appropriations. Fifth, do unprogrammed appropriations violate the constitutionally guaranteed separation of powers? Again, the answer is no. The legislature is given the power of the purse, and in exercising it, the Constitution and jurisprudence require that there is a line item appropriation that corresponds to a single purpose. Did Congress do this? Yes. In the GAA, Congress has identified each specific purpose for which unprogrammed funds may be used, fixed the maximum amount per purpose, specified the 3 exclusive trigger conditions for release, and required administrative certifications and approvals before any peso moves. Did the executive usurp the legislative function of deciding the purpose of some appropriation? The answer is no. What the executive does is not legislative policy making, but administrative implementation. It verifies that a trigger has occurred before releasing funds to a pre-approved purpose in a pre-approved amount. The separation of powers is not violated. The decisions on purpose and amount are made by Congress, and the administrative execution is performed by the executive. The lines that demarcate the constitutional functions are unmistakably clear. Your Honors, this case is not a forum to debate the wisdom of policy choices or the merits of particular appropriations. These are matters entrusted to the political branches and to other mechanisms of accountability, which are also constitutionally provided. The question is whether the existence of unprogrammed appropriations per se violates the Constitution. What is asked of the Court today is the exercise of its own constitutional function to determine whether the limits set by the Constitution have been observed by the Executive and Congress. The inquiry is thus a narrow but fundamental one, whether there has been a breach of constitutional restrictions. This case does not call for an inquiry nor a judgment upon the processes by which Congress determines the contents of appropriations or by which the executive identifies what should be included in the people's budget. We elect our representatives upon whom the people have lodged through the Constitution the power of the purse. We elect the President in whom the people, through the Constitution, entrusts the administration of the budget. Are there governance challenges? Are there better uses of funds? Could certain appropriations be lesser and others more? Does the existence of unprogrammed appropriations make the budget vulnerable to abuse? These questions are not for this honorable court to answer nor to solve. The Constitution entrusts power to the political branches with the expectation of responsibility, not infallibility. Where the mechanism is not prohibited, the answer to potential abuse is not its elimination, but the continued vigilance of the people, whose judgment, expressed through public opinion and ultimately the ballot, remains the highest check in a constitutional democracy. Aside from the power of the ballot, the power of legislative oversight, the power of the Commission on Audit, the power of the Ombudsman, the freedom of speech behind civil society scrutiny are crucial tools under our Constitution to hold the political branches accountable for how they exercise the budget power. The Honorable Court, with its wisdom and authority, can discern the lines drawn by the Constitution with precision, hold each branch to it, and do so with judicious restraint. Your Honors, the Constitution assigned the President the power and duty to propose a budget grounded in fiscal reality. The President did that and followed what was constitutionally required. The Constitution assigned Congress the power and duty to deliberate on that budget on behalf of the people. Congress followed what was constitutionally required. Respect for the separation of powers demands the utmost wisdom of this honorable court. The invalidation of an entire legislative mechanism should not be done unless the petitioners have shown a clear and irreconcilable conflict with the Constitution. It is our position that they have not. Tungkulin ng kapitapitagan at kataas-taasang hukuman ito na bantayan ang mga linyang itinakda ng konstitusyon. Sa ganang amin, sa paghahandang tugunan ang mga pangangailangan ng sambayanan gamit ang unprogrammed appropriations, isinaalang-alang ng ehekutibo at lehislatura ang mga linyang ito, sapagkat ang pagmamay-ari ng kaban ng bayan ay nasa sambayanan. Maraming salamat at magandang umaga po.
Thank you, Solicitor General. May we call Professor Sulita Colliers Monsod as amicus to make her presentation.
If Your Honors please, I have a PowerPoint presentation, but while they're putting it up, I'd like to say that I'm so very glad I'm not a lawyer, because you have lawyers on both sides and you'd think both are right. I am here to, as instructed, to give you a broader view, a non-legal view, an economic view of what is going on in the country today with respect to unprogrammed appropriations. Is it up already? Not yet. Okay. Okay. Sandali lang, ito pa. No, what is happening? Yes, but I'm yes. The presentation is called ABCD, about the budget, corruption, and development. At the heart of this matter, as far as I am concerned, Your Honors, is the abuse of legislative and executive power for private gain, in other words, corruption, occurring during the budgetary process. Such abuse amounts to a large opportunity costs that cannot but impinge on our ability to obtain the development objectives of the country as expressed in the Philippine Development Plan 23-28. What power is being abused? Well, it's the power of the purse. This abuse has been perpetrated in the form of the pork barrel. For the executive, it is the power to choose which programs, projects, activities are to be funded first. It is also the power to release or withhold funds. One of the major dimensions of public budgeting has been planning for economic development through economic growth. A development plan provides a vision, but the budget provides the operational framework. And it goes without saying, but I'll say it anyway, that if the budget fails, the plan fails. And the country pays for it. Then we have the Philippine Development Plan 23-2028, and there are objectives, etc., with results matrices all over the place, about 500 indicators, but there are 11 major indicators. And 3 of those are directly connected with the budget. This is the annual rates of growth of GDP, the national government deficit to GDP, and the outstanding NG debt to GDP. As we all know, the National Expenditure Program is based on a set of macroeconomic assumptions on GDP growth rate, inflation, interest rates, exchange rates, etc., which are in turn based on projections, forecasts of the Development Budget Coordinating Committee, the economic managers. And the NEP is anchored on the Philippine Development Plan. Well, what happened? Well, on November 13, 2013, this honorable court dealt a mortal blow to the pork barrel. We thought it was dead. Policymakers then were faced with 2 choices. They could, 1, institutionalize necessary reforms to public financial management system so that pork could no longer be a problem. In other words, they would pass a proposed Public Financial Accountability Act, ensure projects were owned by the people through bottoms-up budgeting. Or they could devise a new form of pork. That was the low road. They took the low road. Okay. From that November 13 decision, let me update the court. From 2014 to 2016, the President Pinoy Aquino obeyed the Supreme Court. In fact, he abolished the PDAF even before the Supreme Court made its decision. They brought in bottoms-up budgeting, they brought in the Comptroller General and proposed a Public Financial Management Bill, which was introduced but has never been passed. And then from 2016 to 2022, President Duterte also ran on an anti-corruption platform, but the pork barrel came back with a vengeance. Because 2017, Speaker Pantaleon Alvarez said there was no pork barrel because everything was itemized. So if everything is itemized, it does not become a pork barrel. There was a standoff in 2019. The budget had to be, what do you call that? Reenacted, because the president took off $95 billion, 95 billion pesos from the budget. He did it, but in 2020, the Congress recalled the 2020 budget because they wanted to put the 95 billion pesos back in. And that is the time when the contractors became part of the scene. From 2022, a more sophisticated system has come into place where the pork barrel has become a part of the budget preparation embedded in the National Expenditure Program, where there would be no need to make insertions. The so-called baseline balanced management formula, or BBM, was adopted by the DPWH. The entire DPWH infrastructure budget became a pork barrel. The pork barrel system versus the new pork barrel system versus the PDAF. Well, the new pork barrel system obviously is obscenely larger in scale. The PDAF was about 24 billion pesos. And now, since 2023 anyway, the pork barrel is the entire infrastructure project of the budget of the DPWH. divided into allocables and non-allocables. Choice of the projects are made mostly while NEP is being prepared. Note, as testified by the late Undersecretary Cabral, that projects amounted to 50% of the DPWH NEP. Then a legislature may propose projects outside of his district so long as he pays a parking fee or standard operating procedure of 6% to the district representative. This is and finally, here comes the unprogrammed appropriations. The unprogrammed appropriations was chosen as the place to hide the lump sum appropriations. There was the SAGIP and the BIP. The SAGIP is the Strengthening Assistance for Government Infrastructure and Social Programs, and there was something called the BIP. In other words, the unprogrammed appropriations became the repository of these BICAM assertions. And this is where we talk about obscenely large. This is where this graph shows unprogrammed funds appropriations approved, and the approved unprogrammed funds have exceeded proposed unprogrammed funds. Notice in this graph, if your honors please, you will notice that the dark blue line shows where the unprogrammed and the NEP and the GAA were the same as far as unprogrammed and appropriations are concerned. But in 2022, they started growing. And if you'll see that high point there, that's where unprogrammed appropriations started. Wow. They went up to 800 billion pesos, which is more than the budget department appropriations. And notice that the dark blue and the light blue bars is where the general appropriations exceeded the national expenditure program. Anyway, you could see the ballooning of the unprogrammed appropriations. Now, so these unprogrammed appropriations need financing. Serendipitously, it was also starting in 2021 when the budget for expenditures and sources of financing showed unprecedented. It never happened before. But the budget of expenditures and sources of financing showed these excesses of actual revenues over projected revenues. It had never happened before, but it started happening in 2021, 22, 23, and 24, if you will look at those graphs. So, and of course, serendipitously, it happened in the 2024 unprogrammed appropriations. There was an additional provision that said that apart from excess and new revenues, loans for foreign assisted projects, the fund balances of the government-owned or controlled corporations from any remainder resulting from the review and reduction of the reserve funds. Anyway, this provision was put in 24, and it was taken out for the 24-25 budget because I think the Supreme Court did something. Whatever you did something good. Okay. All right. So, what are the direct consequences? We're talking about to the economy and to the fiscal picture. The direct consequences of the unprogrammed appropriations, first, they dilute congressional control over public spending in the following ways. And this comes from the study made by the Congressional Programming and Budgeting Policy Research Department, the think tank of Congress. So it says it weakens budget transparency through legislative scrutiny. it increases. In other words, the legislature cannot scrutinize because this sagip, which amounted about 300 billion in 2024, is essentially a lump sum. It increases the risk to discretionary allocation. Why? Because the president, the executive, decides which one goes out first and which ones should be held up for later release or something. It increases, it blurs this institutional accountability. It undermines fiscal discipline and debt sustainability. It weakens the link to development planning. When items are removed from the programmed appropriations to the unprogrammed appropriations and vice versa, it completely removes the prioritization of the fiscal in the fiscal scene. This is what the CPBRD said. UA, unprogrammed appropriations, originally conceived as a limited standby mechanism to provide fiscal flexibility in the face of uncertainty. However, the rapid expansion in recent years, coupled with weak itemization, conditional funding triggers, post-enactment executive discretion, has transformed them into a budgetary instrument with significant implications for transparency, accountability, and fiscal discipline. Now, the way I read it, that means, it's terrible for good governance. Higher than planned spending, especially when funded through borrowings, could lead to larger annual budget deficits. This resulted partly in the failure of the government to meet its targets for reducing the budget deficit and the deficit to GDP ratio. Let me show you exactly what the effect of these unprogrammed appropriations have been to our budget deficits, to some of our targets. What is the status? For example, in the growth of GDP, that is number one in economic growth target. The actual growth targets versus the growth targets versus the actual. Your orange lines are the actual, and the blue lines are the target. That first graph shows that the growth targets have not been met. In fact, they're going down instead of going up for the years 23, 24, and 25. And then the NG, deficit to GDP ratio. The NG, notice that the actual deficits are much larger than what was programmed, what was put down by the DBCC. In spite of the fact that DBCC started retargeting, those broken lines are the retargeted targets. Notice that still the budget deficits have grown so much between 2023 and 2025. That has to do with the pork barrel. Well, the unprogrammed appropriations is only one way of having a pork barrel. There's the pork barrel that is in the NEP, and then, of course, the BICAM and the unprogrammed appropriations. And finally, the outstanding NG debt stock to GDP ratio. Again, the targets were always to reduce that GDP debt stock to debt stock to GDP ratio. Notice that the orange line is going up. The blue lines are the target, and the broken lines are the retargeted. So, in other words, this is what has happened to some of our targets in the PDP, and these are directly attributable to the pork barrel. Now, what about the status of our income, health, learning development targets? It's too early to tell, but our children and the poor cannot continue to bear the waste and the opportunity costs. As it is, Your Honors, we are an underperformer. 2 weeks ago, that was what we were called. were underperformer among the ASEAN 5. Here are some major areas in which the Philippines is at the bottom. We have the lowest life expectancy at birth among our ASEAN counterparts, the ASEAN 5. We have the highest infant mortality. We have the highest learning poverty rate. We have the lowest tertiary school enrollment rate. We have the lowest human development index. We have the lowest human capital index. We have the highest poverty count ratio. And it is no coincidence that we are also at the bottom for corruption, perception index, the rule of law index, and the ease of doing business index. Well, the bottom line here, the pork barrel is bad news, whether in the form of unprogrammed appropriations or in the form of the DPWH infrastructure budget. It is in the projects are either overpriced and of poor quality, so there is a waste of fiscal funds. And there are large opportunity costs because prioritization is perverted. The prioritization is perverted. The selection of investments are not based on maximizing social welfare. They are based on maximizing private personal gains. Let us all be aware of that. So the development targets may not be met. In the meantime, the Filipino people are robbed, not only at present, but in the future, because these huge, larger budget deficits and the larger debt stock to GDP ratio is going to further constrain the fiscal space later and will constrain the ability of the government to give the people what they need. In other words, Your Honors, strictly from economic point of view, from a rational point of view, the decision is whether to cut down the unprogrammed appropriations or not. And the decision should be always based on, is it worth it? Are the costs greater than the benefits? I feel, given what I have just said, that the costs entailed by the unprogrammed appropriations are so much larger than the benefits, which are contingency, etc., which can be addressed by other things in the budget system. Thank you, Your Honors.
Thank you, Professor Monsod. May we call Senate President Franklin Drilon to make his presentation.
May it please the Honorable Court. I thank the esteemed justices for inviting me to serve as amicus curiae in these landmark petitions involving questions of first impression. Your Honors, while the Constitution provides exhaustive safeguards to ensure that no power remains unchecked, history demonstrates that human ingenuity can elude even the most carefully constructed limitations. And this is what brings us here today. To my mind, I respectfully submit, this Honorable Court must settle two main issues. First, whether including unprogrammed appropriations in the budget is constitutional. Second, in determining whether there was grave abuse of discretion, to what extent may this court define the limits of congressional and executive powers under the framework of judicial review? Unprogrammed appropriations, Your Honor, have been a consistent feature of the national budget, with the DBM, or the Department of Budget and Management's data tracing it back to 1989, and statutory authority predating that record as far back as 1971, with Republic Act 6361 making explicit reference to unprogrammed appropriations. Pursuant to Article 6, Section 25, Paragraph 1 of the Constitution, which states that, quote, the form, content, and manner of budget deliberation or budget preparation shall be prescribed by law, end of quote. Congress has consistently integrated unprogrammed appropriations as a component of the General Appropriations Act. It is fair to conclude that until the present controversies surrounding unprogrammed appropriations, successive administrations and Congresses alike have assumed its constitutionality. Save for the Belgica and Araulio cases, the unprogrammed appropriation has remained largely unexamined. Complete clarity, however, after all, is a privilege afforded only by hindsight. Questions on its legitimacy only arose after a marked increase in the unprogrammed appropriation from the National Expenditure Program, or the NEP, to the General Appropriations Act, contrary to the historical parity between the two, with modest to no deviations at all. I submit respectfully, Your Honors, that the unprogrammed appropriation functions as a special appropriation contained in the General Appropriations Law. Consistent with Article 6, Section 25, Paragraph 4 of the Constitution, it specifies the purposes for the appropriation and is released only upon certification of the Treasurer that funds are actually available or will be raised by a corresponding revenue proposal. It serves as a standby authority contingent on revenue windfalls not accounted for on the base in the budget of expenditures and sources of financing, or BESF. In its standard formulation, assuming the conditions are strictly and fully observed, unprogrammed appropriation does not increase the President's recommended budget ceiling. I repeat that, Your Honor, for emphasis. In its standard formulation, assuming the conditions are strictly and fully observed, the unprogrammed appropriations does not exceed the President's recommended spending ceiling. Thus, isolated from implementation concerns and the GOCC funding sweep, and program appropriation appears to be consistent with the mandate under Section 25, Paragraph 1 of the Constitution. I also submit, Your Honors, that classifying funds as either programmed or unprogrammed is an exercise of the power of the purse. Whether an item is accorded immediate or contingent funding is a deliberate policy decision rooted in the wisdom of Congress to balance immediate operational mandates against contingent fiscal realities. Recent unprogrammed appropriations, however, include funding for regular agency operations, personnel benefits, and other recurring expenses. Foreseen operational costs better included in the programmed rather than unprogrammed appropriations. When the legislative wisdom falters, I concede that the temptation to declare the entire concept of unprogrammed funds as unconstitutional is very strong. We concede that, Your Honor. I humbly submit, however, that the decision to no longer include unprogrammed funds as a component of the annual budget or to strictly define its nature is a matter vested in the Constitution in our political bodies, Congress and the executive branch. And I quote, "The form, content, and manner of preparation of a budget shall be prescribed by law." When the unprogrammed appropriations has been a consistent feature of the General Appropriations Act, the special provision on their release have undergone several iterations throughout the years. In the 1989 General Appropriations Act, the special provision states that, quote, "No item may be programmed until after the first quarter of 1990, when the Development Budget Coordinating Committee shall determine and certify that revenue targets of government have been met," end of quote. In the 1991 General Appropriations Act, the release of funds were conditioned on excess revenue collections over the BESF, citing Article 7, Section 22 of the Constitution. The special provision further states that no amount shall be funded out of savings generated from the programmed items in the General Appropriations Act. The current iteration, Your Honors, of the special provisions of the unprogrammed appropriations first appeared only in 2015, no longer tying the release to the general excess over BESF targets, but upon A, excess collections from any identified non-tax source. And I underscore the word any, meaning, even if the general revenue program is not met, if any item of the revenue program is exceeded, then that gave the authority to fund an unprogrammed appropriation. To me, that is a very wrong and malicious interpretation of this provision of law. As early as Araulio versus Aquino, the executive has maintained that excess collections should be measured per individual BESF revenue source, a view made explicit in the 2015 GAA and thereafter. Despite being a respondent in that case, I respectfully invite this honorable court to revisit its pronouncement on unprogrammed funds. To release unprogrammed funds, the unprogrammed funds simply because there was an excess as to one source of revenue would be an unsound fiscal management measure because it would disregard the basic budget plan and foster fiscal deficits in contravention of the government's surplus budget policy. Before the present petitions, the phrase, quote, "funds actually available," end close quote, under Article 6, Section 25, Paragraph 4, has not been defined, and releases based on excess from a single source was presumed to be a valid exercise of of the Treasurer's certification. We emphasize this and invite this honorable court to give special attention to this practice and provision in the General Appropriations Act. My humble submission that to preserve the unprogrammed appropriation as a valid fiscal tool within the General Appropriations Act, it must be strictly sourced from funds annually available, triggered by genuine windfalls, measured against the aggregate of the President's original BESF revenue targets in line with Article 7, Section 22 of the Constitution. Ideally, the program budget should be completely covered by funding before any excess is declared. If one source exceeds the target, while the total national budget is below the BESF aggregate, then strictly speaking, no funds are truly available for release. To rule otherwise will result in the absurd situation where the unprogrammed contingencies are funded ahead of the programmed mandates. Using the aggregate standard also cuts the temptation to fill the unprogrammed appropriations with pork barrel projects, knowing that funds will not be easily released. I maintain, Your Honors, that unprogrammed appropriations are not inherently unconstitutional. However, when the low threshold of excess revenue funds the inflated list in the unprogrammed appropriation, including those moved from the program budget, the funding appears to be no longer contingent, but almost certain. It also loses its character as a special appropriation and instead operates as a disguised general appropriations that may serve to expand the footprint of the original budget submitted by the President. In this perfect storm, Your Honors, the violation is not found in the text of the law, but in the arithmetic of its execution. Thank you very much, Your Excellencies.
Thank you. Okay. May we call Honorable Benjamin Jokno to make his presentation.
Chief Justice, Your Honors, good morning, still morning, right? Allow me to present my comments on the pending Supreme Court petitions questioning certain provisions on unprogrammed appropriations in the 2024, 2025, and 2026 General Appropriations Act. As former Senior Undersecretary and Secretary of Budget and Management, I have prepared 13 of the 39 post-EDSA 1 revolution national budgets, including the first and only budget under the Freedom Constitution. Notably, the 1987 budget already contained unprogrammed appropriations. From 2026, rather from 2005 to 2026, Congress approved unprogrammed appropriations exceeding those proposed by the President only 5 times. In 2010, under President Arroyo, in 2022, under President Duterte, and from 2023 to 2025, under President Marcos Jr. The increases over the last 3 years, however, have been particularly large. So those are encircled there. Back, please. The blue line is the one in the NEP, and the red line is the one approved by Congress. This is not to argue that Congress may increase the unprogrammed appropriations as requested by the executive. This is only meant to reflect the monumental abuses done by Congress during the last 3 years, 2023, 2024, and 2025 national budgets. By design, unprogrammed appropriations serve as standby appropriations. The budget planning, preparation, and authorization process is complex and time-consuming. For example, Preparation for the 2026 budget began as early as January 2025 with a budget call. Now, some foreign assisted projects, which may be seen as the most senior of all budget items since they undergo a series of studies, are considered but not completed or approved a year prior to the start. FAPs are among the most rigorously evaluated budget items. Let me repeat that. The foreign assisted projects are among the most rigorously evaluated budget items. They undergo pre-feasibility study, feasibility studies, detailed engineering, and a review of the internal rate of return threshold by the NEDA Investment Coordination Committee. Now, despite their merit, these projects risk delay due to the constitutional requirement that no money shall be paid out of the Treasury except in pursuance on appropriation made by law. So delays in the implementation are costly, and they result in the payment of commitment fees to multilateral financial institutions. That's why we have standby appropriations for foreign assisted projects. Now, the national budget is the most consequential piece of legislation enacted by Congress. In a tripartite system of government, the executive branch is generally understood to have a comprehensive view of national priorities, better access to domestic and global data, superior assessment of bureaucratic capacity and revenue potential, and a broader perspective and better appreciation of deficit levels and debt sustainability. Congress, which holds the power of the purse, directly represents the people. No offense meant to our former legislators here, but legislators often have a more localized, particularistic view, focusing on deliverables for their respective constituencies. And so this may be the rationale for the constitutional provision that Congress may not enact a budget larger than what was proposed by the President in the budget of expenditures and sources of financing. Now, let me go directly to the unprogrammed appropriations. The size of the unprogrammed appropriations is driven mainly by the number and the amount of foreign assisted projects not included in the proposed budget, but likely to become effective during the forthcoming fiscal year. It also depends on the likelihood that actual revenues will exceed projections in the BSF. Historically, deviations between projected and actual revenues have ranged from negative, in other words, we have actually under-collected rather than over-collected, 19.2%. That happened during the COVID years, understandably, to 10.6% in 2021. There is a wide variation in unprogrammed appropriations as a share of the total budget across administrations. It was highest under President Marcos Jr. at 9%, and lowest under President Duterte at 3.9%. Finally, on whether Congress validly increased or earmarked funds for the Road Users Fund by reallocating items in the 2025 General Appropriations Act, the Department of Public Works, full disclosure, I worked for the abolition of the Road Users Board. It was a good law, but the way it was implemented was anomalous during the GMA years. So I moved for the abolition of the Road Users Fund, Board rather, but the fund remains. And so under the current system, the Department of Public Works and Highways alone determines the available road users fund for the fiscal year, the required expenditures for road maintenance, and that, of course, depends on a formula, the length of the existing roads, the need for maintenance every 5 years for for good roads and maybe annual for the poor roads, and of course also the operational capacity of the DPWH. This amount is incorporated by the Department of Budget and Management into the President's budget, with a commitment of the DPWH Secretary during the Cabinet meeting, approximately 1 month before the opening of Congress. That is the last Cabinet meeting to tackle the budget. The DPWH Secretary is committed to the President as to the amount of that road users fund. And this is prior to the BSF and the National Expenditure Program. Given this process, the basis for increasing allocations beyond what was proposed by the executive is unclear. And so the next table will show you the deviations. The President proposed in 2022 15 that's billion, 15.192 billion. Well, Congress reduced it. That's in accordance with the Constitution. Congress may not increase, but may decrease. In 2023, the President proposed 15.192 billion. Congress increased it to 21.231 billion, or 39% increase. 2024, the President or the DPWH Secretary and approved by the President asked for 15.2 billion. Congress increased it to 24.5 billion, or 61.2% increase. In 2025, 16.755 billion, that was the request of the President. Congress increased it by 107.4% to 34.748 billion, equivalent to 33.4 billion for the 3 years. That is approximately equivalent to 66,800 school rooms at $500,000 per school room. In my view, these increases is inconsistent with the constitutional provision that Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. Thank you very much.
Thank you. Okay. May we call Professor Secretary Abad for his presentation.
The Honorable Chief Justice, Senior Associate Justice, Associate Justices, good morning. May it please the Court. The question before this Honorable Court do not concern merely the validity of particular provisions in an appropriation law. They go to the heart of the Constitution's design over the public purse and the system of accountability that it commands. The 1987 Constitution, at its core, is an accountability constitution. It structures the national budget not simply to allocate resources, but to ensure that public funds are raised, authorized, and spent under conditions of transparency, discipline, and institutional control. At the center of that structure is a fundamental requirement that the national budget must be a financed fiscal program. Under Article 7, Section 22, the President submits to Congress a budget of expenditure and sources of financing. the BESF. The submission is not a formality. It is the constitutional anchor of the appropriation process. It reflects a basic but indispensable principle that expenditures must correspond to identified and available sources of financing. This structure is reinforced by a further constitutional restraint, the budget ceiling. Congress may not increase total appropriations beyond what the President has proposed. Taken together, these requirements ensure that the budget is not an open-ended wish list, but a coherent fiscal program grounded in reality. The constitutional process is thus carefully sequenced. First, the executive formulates a finance fiscal program. Second, Congress exercises the power of the purse within that program. Third, the executive implements the budget as enacted. The sequence, Your Honors, is not procedural convenience. It is a constitutional safeguard designed to preserve both fiscal discipline and institutional accountability. And program appropriations must be understood within this constitutional structure. In practice, the Philippine fiscal system operates under persistent deficit conditions. Over the past 4 decades, budget surpluses have occurred only briefly during the administration of Fidel V. Ramos, and even then, only in modest amounts. More importantly, Your Honors, revenue targets have been exceeded in only a handful of years. This means that in the ordinary course, the conditions required to validly trigger and program appropriations do not exist. As this court made clear to Arroyo versus Aquino III, excess revenue, quote unquote, must be determined holistically based on total revenues relative to total projections in the BESF, not on isolated gains from particular sources. Accordingly, under normal fiscal conditions, unprogrammed appropriations are not meant to operate. They are by design exceptional. There have been instances, however, where unprogrammed appropriations were activated, not on the basis of genuine fiscal surplus, but through fragmented and selective interpretations of revenue excess. Prior to this court's clarification in Arroyo, the position was taken that excess collections from individual revenue sources, such as GOCC dividends or non-tax revenues, could justify releases. This court rejected that approach. It held that revenue must be assessed in its totality. Isolated gains cannot create artificial surpluses. And to treat them as such is to risk unsound fiscal management, increasing borrowing and expanding the deficit. Subsequent rulings, including Pimentel III versus House of Representatives, further clarified that funds earmarked by law do not constitute disposable revenue. But even assuming, Your Honors, valid activation, the deeper constitutional issue remains. In a situation where deficits are the norm, additional revenues, when they arise, are rarely sufficient to fund all unprogrammed appropriations. The reality forces three decisions: which appropriations will be funded, which will not, and in what amounts. These are not technical decisions. They are allocative judgments about public funds. Yet, by that stage, the appropriations law has already been enacted. These decisions, therefore, occur during budget execution and are made by the executive. In practical terms, Your Honors, the executive determines which among legislatively authorized appropriations will actually become operative expenditures. That, Your Honors, is the constitutional problem. It is not merely a matter of administration. It is a displacement of accountability. The Constitution assigns to Congress the authority to decide which public purposes receive funding and to what extent. But when funding is insufficient, that decision effectively migrates from legislation to execution. Recent practices raise an even more serious concern, Your Honors. When unprogrammed appropriations are expanded beyond fiscal limits and treated as readily activatable, they risk becoming not merely contingent spending authority, but a mechanism for circumventing constitutional restraints. In particular, they raise questions as to whether the budget ceiling itself is being observed or effectively bypassed. And when allocations depend on discretionary activation, they risk becoming opaque instruments of spending, weakening transparency and undermining the Constitution's accountability safeguards. It is sometimes argued, as was here, that unprogrammed appropriations are necessary for flexibility. But the Constitution already provides that flexibility, and does so without sacrificing accountability. Under Section 6, Article 25, Section 25, subsection 4, Congress may enact supplemental or special appropriations supported by funds actually available or by revenues to be raised. This mechanism preserves flexibility while ensuring that decisions on public spending remain within the legislative process where the Constitution places them. Your Honors, the constitutional rules governing the national budget are not mere technicalities. They are structural safeguards designed to preserve the separation of powers and ensure accountability over public funds. This court has consistently upheld these principles in Belgica versus Executive Secretary and Arroyo versus Aquino. In conclusion, the Constitution already provides a complete framework for fiscal governance. The issue before the court is not whether flexibility is desirable. It is whether that flexibility may operate outside the constitutional structure that governs the budget. The Constitution allows flexibility, but it requires that decisions on how public funds are spent remain within the legislative appropriation process and do not migrate into the execution stage of the budget. To allow otherwise is not merely to relax a rule, it is to reconfigure the allocation of power over the public purse. And that, Your Honors, is a constitutional question of the highest order. Thank you.
Thank you, Secretary Abad. Considering it's 5 minutes after 12, the session is suspended to resume at 1:30.
Tatalian gamit ang mata.
All please rise. The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
So we'll proceed with the interpellation by the justices. First to interpellate is Senior Associate Justice Mario Victor F. Jonen.
Thank you, Chief. With leave of the court, may I ask the Solicitor General to take the podium? Thank you, Madam Solicitor General. I hope that you had a good lunch. I understand that the Solicitor General's office provided for their own packed lunch.
Yes.
Yes, but just to inform you that we provided food for everybody else, just for disclosure purposes. So the amicus and the petitioners' counsel. But we thank you for saving the court some expense.
We did not want to assume that we will be included.
Yes, and please don't assume next week, next time again. That is fiscal discipline. Now, just to start off, so there is what is called a the budget of expenditures and sources of funds. This is called the BESF, just so we are familiar with the terminology. And the BESF is a part of the NEP, the National Expenditure Program, correct?
Yes, Your Honor.
And the National Expenditure Program contains the BESF, the Budget for Expenditures and Sources of Funds, and a more detailed listing of the expenditures divided by purpose and divided by classification, correct?
Yes, Your Honor, plus the automatic appropriation, but
Yes.
only for information.
Yes. Yes, and it seems that is one of the issues that we have also for this case, that from your perspective, there are three parts. There is the program, there is the unprogrammed, and there is the automatic appropriation. But on the other end, they are classifying it only as programmed and unprogrammed. But that nonetheless, just so we are familiar with the figures. And then there is what is called a total expenditures for the program, a TEP, correct?
Yes, Your Honor.
And this is the total amount for the NEP that is proposed by the budget of the President, correct?
Yes, Your Honor.
Just so we're clear, the NEP, the National Expenditure Program, is otherwise called the President's budget, correct?
Yes, Your Honor.
Yes. And after the President's budget goes through the House of Representatives, the House of Representatives produce a General Appropriations Bill, or what is often referred to as the GAB, correct?
Yes, Your Honor.
And after that, it is given to the Senate, and in the Senate, they just call it the bill on third reading, correct?
Yes, Your Honor.
And after that, if there are disagreeing provisions, they call a bicameral conference committee, or a BCC, and this BCC therefore produces a proposed resolution where both houses will ratify, correct?
Yes, Your Honor.
And from there, they produce the General Appropriations Act for the signature of the President, correct?
Yes, Your Honor.
And after the GAA, the President exercises a different kind of veto. We will examine that later, which is called a line item veto, correct?
Yes, Your Honor.
And the President signs the GAA within a set time. Otherwise, it will be reenacted. But along with his signature, the President formally communicates his vetoed items to the House and the Senate, correct?
Yes, Your Honor.
And the House and the Senate may overturn the veto based on the Constitution by a 2/3 vote, correct?
Yes, Your Honor.
Yes. Now, do you recall the amount of unprogrammed funds proposed in the NEP, National Expenditure Program, of the President in 2024 for unprogrammed? You recall the amount?
Yes, Your Honor. I have it in my notes. The unprogrammed appropriation proposed by the President in the NEP for 2024 was 281
281
billion.
908 million 056, correct?
Correct, Your Honor.
Yes. How much was the approved on third reading in the GAB, the General Appropriations Bill of the House, in terms of unprogrammed appropriations?
Your Honor, I only have what's in the GAA.
It was 281 billion 908 million and 56, similar to the NEP.
Okay.
Would you know how much in terms of unprogrammed appropriations did the Senate approve before the BICAM? Again, it was 281 billion 908 056. So as far as we are concerned, in 2024, which is the subject of the petition of Lagman et al. And Pimentel et al., the NEP was 281 billion, the GAB was 281 billion, the Senate was 281 billion, correct?
Correct, Your Honor.
And how much was the proposal of the BICAM when it met to conciliate disagreeing provisions? How much in unappropriated, unprogrammed appropriations?
Your Honor, it is 731 billion 448.
So it was 731 billion. Okay?
Yes, Your Honor.
And just so we are clear, let's show the slide so everybody knows what we are talking about. So up there, you will see now NEP 281, GAB 281, Senate 281, BICAM 731. Correct?
Correct.
Madam Soljen. And per your argument, this is something that we should respect because it is an act of wisdom on the part of both houses to increase what was not debated upon from 281 to 731, meaning that there was a difference of 449.5 billion added into unprogrammed appropriations, correct?
May I qualify my answer?
Yes,
Your
yes,
Honor?
please, go ahead.
It is a question of wisdom because when we say an act of wisdom, it might be ambiguous as to there's already a judgment if it was wise
Yes.
or not.
Yes.
And the hope of our hope is for the court to rule on a narrow question as to checking whether the power that was exercised by the Congress is within the constitutionally required constitutional requirements or if it was within the limitations that are provided by the Constitution, Your Honor.
Okay, I will take that for now. In terms of total expenditures under the NEP, the National Expenditure Program of the President in 2024, would you recall how much it was? It was 4,301,676,000,000 and some thousands of pesos, correct?
In my notes, Your Honor, it is the total expenditure program is 5.7
For the NEP,
billion.
under the NEP,
For the
2024.
for the NEP,
It was 4.3, correct? At any point, Solgen, if the DBM representative is here, the chief has reminded me that you may consult with the Department of Budget and Management if they are here.
There are representatives of the DBM
Here. That's good to know because we might ask for an increase in the budget of the judiciary also. But that nonetheless, so it was 4.3, and in 2024, the total GAA expenditure was 4.7. Again, I put up the slides. Correct me if I am wrong. In 2024, the NEP was 4.3, the GAA was 4.7. So in terms of the total, it was increased. And the NEP, correct me if I'm wrong, Madam Solgen, the NEP contained both program and unprogram, correct? The National Expenditure Program or the President's budget already contained a proposal for unprogram, correct?
Yes, Your Honor.
So the NEP is both program, automatic, and unprogrammed, correct?
Yes, Your Honor.
But in 2026, which is also a budget in issue today, this is the petition of Congressman Erice, who was here, and Congressman De Lima. The NEP was 4.6 billion, correct?
For 2026,
I put it up there. But what was actually approved by the houses, by both houses, and the President was lower. It was 4.646, with a corresponding decrease also in the unprogrammed appropriation, correct?
yes, Your Honor.
Yes, okay. So that we know what we're talking about, in 2024, we will start to put up now the additions in the unprogrammed fund that was included after not the third readings of the houses, both the House and the Senate, but after the BICAM. So the first slide will show you, let's put up the slide, Panay Guimaras Island Bridges Project, 3 billion. Universal access to quality tertiary education, 7 billion. This was from the program transferred into the unprogrammed, correct, Solgen?
Yes, Your Honor.
And universal access to quality tertiary education, would you know if there is a law that actually requires funding for this? Universal access to quality tertiary education.
May I confer, Your Honor, with my team?
Yes, you may defer your answer until, unless you have it now, yes? Is this the Bamakino law? Yes, and this is the law that actually provides free tertiary education, which was first under the President's budget program. But in 2024, it was moved to unprogrammed. And later on, of course, we will ask questions about whether this is in fact not only constitutional, but whether it was legal that it is moved from one program item to unprogrammed. Then there is number 11, a quite interesting nomenclature, priority social programs for health, social welfare and development. It says priority, but this also came from program and it was transferred to unprogrammed, correct?
Yes, Your Honor.
Okay. The AFP has been wanting modernization for a long time, but the revised AFP modernization program of 10 billion, is this billion? Yes, was transferred to unprogrammed funds, correct?
Correct, Your Honor.
Yes. Then also, payment of right-of-way was transferred from program to unprogrammed, amount of 3 billion, correct? Yes.
Correct, Your Honor.
And then pre-feasibility studies, preliminary and detailed engineering, 3 billion. Later on, we will encounter this again. And then next, public-private partnership, strategic support fund, maintenance, repair, rehabilitation of infrastructure. Number 17 is interesting. government counterpart of foreign assisted project in the amount of 51 billion. This is different from the item on foreign assisted projects that I will show you later. This came from program. This was a definite expenditure for government counterpart for foreign assisted projects. It was moved from the program funds to the unprogrammed. Then next, for the repair, rehabilitation, and expansion of Dalawag International Airport, I can only guess who transferred this. Payment of personnel benefits in number 19. Madam Soljen, you agree that 59 billion for payment of personal benefits was considered as unprogrammed from program, correct?
Yes, Your Honor.
Then, pension and gratuity fund. This means that the retirement fund of a lot of our government employees, and I can only guess perhaps a portion of this, some of our judiciary personnel not covered by our existing law, 40 billion, 250 also to the unprogrammed, correct?
Yes, Your Honor.
Then you have the libreng sakay became unprogrammed, correct?
Yes, Your Honor.
Also, the screening of anti-terrorist equipment, etc., unprogrammed. National Data Privacy Program, 620 million, became unprogrammed. Preparation for national election in 2025, since there was no election, perhaps they moved it to unprogrammed. Construction and repair of NFA warehouse facilities, also unprogrammed. Development and modernization plan for the Iwahig. Then the next slide, you will see there, interestingly, acquisition of fire trucks became unprogrammed, not programmed. Then digital agriculture project also became unprogrammed. Then the next slide, aquaculture, fisheries, Marawi siege victims compensation program. This is the long-awaited compensation to the victims of Marawi. From program, it was transferred to unprogrammed. Supplementary feeding program, I think this was for younger kids that were indigents. Then, next slide, the creation of lawyer positions in the PAO became unprogrammed. Perhaps lawyers are not that important anyway. And then we have, finally, the last one, number 50, OWA Welfare Services. This is the office that produces support for OFWs, was also moved to the unprogrammed funds. This was in 2024. Oh, and total, at the end, there is local government support fund. In the amount of 5 billion was moved from program to unprogrammed. We will ask you later what this is, what this item is all about, or perhaps some of my colleagues will be able to ask you if I cannot. And the total in terms of additions to unprogrammed was 303 billion, correct?
Correct, Your Honor.
But this was not all. There was an increase in the already set items for unprogrammed. And the first one was mentioned by one of our amici as, and she called it a new pork barrel. I will not go to that extent because that may be a legal terminology, but it is definitely perhaps a lump sum item, which was covered also in the case of Arroyo, Belgica, especially the Belgica of 2013, penned by Justice Ben. So the NEP proposed that the SAGIP program was only 50 billion, but in 2024, this lump sum was increased to 225 billion pesos, correct?
Correct, Your Honor.
And for support to foreign assisted projects, maybe they were, as one of our amici was saying, they were predicting that some of the foreign assisted projects in the pipeline might be approved. It was increased from 117 to 178, correct?
Correct, Your Honor.
So this is the situation that I think all of us are agreed upon, which is now at issue, because 2024, as shown by our various amici, was the year where there was an extraordinary increase in the amount of unappropriated, unprogrammed funds, not unappropriated, but unprogrammed funds. Okay, now let us proceed. The concept, let's talk about the architecture in our Constitution, because we need to talk about the various provisions in context so everybody understands it. So the Constitution does not give one branch of government what is usually referred to as the power of the purse, because the power of the purse is big and consistent with the architecture of the Constitution. The contents of that power are distributed among constitutional departments and organs. Do you agree?
I agree, Your Honor.
And the basic idea behind separation of powers is to prevent tyranny and ultimately to increase accountability, correct?
Correct, Your Honor.
The separation of powers doctrine assumes that unchecked power tend towards tyranny. So liberty requires institutional restraints within government, assigning functions to distinct organs. The structure expresses a rule of law ideal, which is that governments must proceed in temporarily ordered phases: legislation, administration, adjudication, and accountability, rather than through undifferentiated sovereign will. You agree?
I agree, Your Honor.
And appropriation and spending funds are critical for governance. You agree?
I agree, Your Honor.
Appropriation and spending funds is not only because of whim, but it is part of an overall plan of the executive and hopefully with the participation of the legislative. And in our case, as presented by one of the amici, there is actually a Philippine Development Plan, correct?
Correct, Your Honor.
And it is from 2023 to 2028, correct?
Correct, Your Honor.
Yes. Just to take note, the court has an SPJI, strategic plan also, and we are implementing it with budgeting also here. So, but in a political economy where there is a deficit of equality, where there is poverty, and when therefore there is a lot of disempowerment, with most of our people being only able to govern through voting and dissent and criticism, the extent of prerogative of those in departments or constitutional organs must be clearly and adequately defined. Do you agree?
I agree, Your Honor.
And in interpreting the Constitution, though, apart from this purpose, we must be mindful as the court that the judiciary, unlike the executive and the legislative, is not possessed with complete, current, and contingent information. You agree?
Agree, Your Honor.
And that the executive must also be given some appropriate leeway by both this court and Congress to address the current situation. You agree?
I agree, Your Honor.
And that laws, including the General Appropriations Act, are frameworks and limits plans of action, but they do not and should not unduly shackle the executive to address what has not been fully foreseen despite reasonable and diligent efforts, correct?
Correct, Your Honor.
Like the situation we have today, that when the budget was passed, no one could have imagined what will happen in the Middle East, correct?
Correct, Your Honor.
But I am sure, and we are witness to the fact that both the House and the Senate are currently investigating, holding hearings in aid of legislation to see what they can do to supplement whatever powers are needed by the President to address the current situation. In fact, they passed a law allowing the President to suspend excise taxes, correct?
Correct, Your Honor.
Yes. In other words, we should be mindful that we should not straitjacket the reading of the text of the Constitution, even with precedents, and make sure that the Constitution should be a living but empowering document, correct?
Correct, Your Honor.
Yes. Empowering, but also a document with accountability, correct?
Correct, Your Honor.
Because as Richard Posner said, the Constitution is a living document, but it is not a suicide pact, correct? In other words, the Constitution is a living document. However, it's not a suicide pact. In other words, all the departments must be rational in terms of arriving at their own conclusions with respect to their own power canalized, correct?
Correct, Your Honor.
Okay. And for a purpose of exercising the power of the purse, just so that we are all clear, this is divided as follows. The executive, the president, and there's only one executive in the Constitution, it's the president, and everybody is the alter ego, prepares the budget, correct?
Correct, Your Honor.
The legislature, and that is Congress, with the House acting first, authorizes or appropriates, correct?
Correct, Your Honor.
Then the president, and the president only, spends or executes with clarification, again, by our case in 2013, that the legislature has no participation in the post-enactment or execution stage. You agree?
Agree, Your Honor.
And the Commission on Audit, as a constitutional organ, checks on the expenditures, correct?
Correct, Your Honor.
The Ombudsman can prosecute, correct?
Correct, Your Honor.
And the judiciary, of course, is tasked with interpreting the boundaries of these powers as contained in the text of the Constitution and in statutes, correct?
Correct, Your Honor.
Now, during your presentation, in your opening statement, you mentioned the case of KMU versus Aquino. Do you recall in what context? That KMU versus Aquino is the ponencia that actually said that the court respects that all the organs of government can have first crack at the interpretation of the text of the Constitution, and it respects that, correct?
Correct, Your Honor.
But then there is also some wording in that case that says that in the final analysis, it is the duty of this court to give a final reading, correct or wrong, correct?
Correct, Your Honor.
Yes. Would you know how I know?
You were the ponente.
Yes, I was the ponente, and the case was unanimous in terms of this court. Okay. Now, let's look at the actual provisions in the budgetary process so that we are also clear. To look at the architecture of the Constitution, we start with the basic provision in Article 6, Section 29. So it's up there. No money shall be paid out of the Treasury except in pursuance of an appropriation made by law. You agree with me that this single provision shows the relationship between the executive and the legislature, correct?
Correct, Your Honor.
Yes. Is there any other money that can be spent by government that is not in the Treasury mentioned in the Constitution?
No, none, Your Honor.
All collections are submitted to the Treasury except for fiscally autonomous institutions like the judiciary, because there is a separate provision in the Constitution for that, correct?
Correct, Your Honor.
Yes. So the whole cycle includes preparation of the budget, appropriation, budget execution, and budget audit. Agree?
I agree, Your Honor.
The issues we now face are generally about that stage of authorization or appropriation, correct?
Correct.
With its impact on preparation and execution, but principally about authorization. You agree?
I agree, Your Honor.
So, in terms of preparation, the provision, the basic provision on the part of the executive is Article 7, Section 22, which states that the President shall submit to the Congress within 30 days as basis for the General Appropriations Bill a budget of expenditures and sources of financing, correct?
Correct, Your Honor.
Yes. And the budget of expenditures and sources of financing in the current interpretation, in practice, contemporary executive interpretation, and in the law as contained in the administrative code, the BESF is actually the budget of expenditures and sources of financing, correct?
Correct, Your Honor.
And it says, including receipts from existing and proposed revenue measures, correct?
Correct, Your Honor.
At some point, we will see that the word including is contested by the respondents and one of the petitioners. But it's very clear here that the President only submits one budget, correct?
Correct, Your Honor.
Because it says a budget of expenditures and sources of financing. We will relate this later to Section 25, subparagraph 1, in relation to the increases in the budget of the President, correct?
Correct, Your Honor.
Yes. And the budget contains, you agree with me, sources of financing, correct?
Correct, Your Honor.
Yes. Now, parenthetically, no, here. Does this provision allow deficits? In other words, is there anything in our Constitution that says that our budget must always be a balanced budget?
None, Your Honor.
Madam Soljan, just to be clear, what is a balanced budget?
A balanced budget, Your Honor, is you have expenditures, and the expenditures will have to be supported by the sources of financing.
Yes. So, would you say, so this allows for this statement, and the Constitution allows that the President actually tells Congress, we are going to have a deficit, correct? Based on the projected revenues as well as the expenditures, that we will have deficits, correct?
Can you repeat your question?
In other words, that the Constitution allows the President to communicate to Congress through the NEP and through the budget of expenditures and sources of finance, that we are expecting to have a budgetary deficit, which means that our current income revenues coming from tax and non-tax measures will not be sufficient to cover the proposed authorization of expenses, correct?
Correct, Your Honor.
Yes. Sa madalit salita, pwedeng sabihin ng Pangulo sa ating Kongreso na ang kanyang budget ay kulang sa revenue, pero mas marami ang expenditures. Tama?
Tama, Your Honor.
Yes.
May I clarify
Yes.
also? In our briefings by the DBM, what we understand is that even the deficit spending is being planned, and part of
Yes.
there is a deficit framework.
Yes.
Globally, there could be a target level which is accepted as an acceptable level, and it will depend on our executive branch
Yes.
as to what that level is.
Actually, later, we will go into a bit of the economics just to make sure that people know that this is legitimate to have a deficit financing. I will not go into it with you. I will go into it with some of my former professors. And I do so with a lot of trepidation because I did get a high grade in basic economics from Professor Monsod, and also a higher grade in public finance from Professor Dr. Jokno. And I don't know if they can recall those grades now. But in any case, subject to contempt of court, of course. So deficits are there. Mainly, they can be filled in by income. Let us say they did not predict that there was high dividends from one of our government-owned and controlled corporation, non-tax revenue, correct?
Correct.
Or perhaps a new tax that would be passed by government, correct?
Correct.
Or a good performance of our economy, therefore increasing the amount that we collect in, let us say, value-added tax because there is more transactions, correct?
Correct, Your Honor.
So also, it can be filled in by borrowings.
Correct.
Such as, for instance, when the Monetary Board issues a treasury bill of different maturities depending on their monetary policy. And these are actually borrowings that we have, correct?
Correct, Your Honor.
And technically speaking, all our currency is in a debt, except that we will not get into that, correct?
Thank you, Your Honor.
And that it is also possible that we borrow from foreign sources, correct?
Correct, Your Honor.
And with respect to foreign sources, that is also regulated by the Constitution, more specifically Section 20, which actually says that the only, that we can contract, the President may contract foreign loans only with the prior concurrence of the Monetary Board, correct?
Correct, Your Honor.
And that the Constitution also says the discretion of the Monetary Board and the President to contract foreign loans can be regulated also by Congress because it says as may be provided by law, correct?
Correct, Your Honor.
And that at the end of each calendar year, there is a submission to the Congress so that they can monitor our foreign loans and what we have guaranteed. There is a report, correct?
Correct.
And that the manner of this report can be governed also by law, correct?
Correct, Your
So there is a check and balance with respect to foreign borrowings, and this was wisely included in our 87 Constitution. It was not in our 35 Constitution by the constitutional commissioners. One of them is actually present in the session hall right now in the person of Commissioner Christian Monsod, correct?
Correct.
Yes, and I had the privilege of being a research assistant of a constitutional commissioner. I carried the briefcase of one of them at that time, so I know how they thought in a while. Okay, and domestic borrowings. Who authorizes domestic borrowings, if you know?
May I confer?
The Monetary Board for Treasury Bills, etc., and others. Okay. Now, all these proposed borrowings, should they be indicated in the budget of expenditures and sources of financing?
It should be included.
So it is there. It is part of the premise of the budget that is given there. They are going to say, the President is going to say in the BESF that there are going to be loans. So in other words, the NEP already contains all the premises for all types of budget, program, unprogram, etc. Correct?
Correct, Your Honor.
Yes. And now let's look at authorization, just so we're on the same page. One of the main bases and the point of contention is Section 29, well, not really contention, but 29, subparagraph 1 and 3 of Article 6. So we already mentioned subparagraph 1, and then there is the concept of a special fund, and this was interrogated by the court in the latest case of involving PhilHealth with Justice Ami as the ponensya, for which our amici Professor Monsod said we did something good, correct?
Correct, Your Honor.
Yes. So there is a special fund to be differentiated from a special appropriations law. There are laws that create special funds, correct?
Correct, Your Honor.
Very briefly, are these special funds the SAGF, special allotments in the general fund? Is this the same?
The special fund, if the law that provides for the special fund says that it is automatically appropriated every year, then it goes to a SAGF, it goes to an account.
So all special funds are or should be in SAGFs, correct? And not all SAGFs are special funds.
Yes, that's correct.
Okay. Incidentally, the legislature is also involved in terms of taxation as a revenue source, correct?
Correct, Your Honor.
So therefore, when the President says that in the BESF, that it will request for new revenue sources, it will in fact be signaling to Congress that they will be proposing new taxes, correct?
Correct, Your Honor.
Yes, and this is covered in Section 28. I will just flash it briefly, just so we know. Now, there are limits to what Congress can do with respect to the President's budget, correct?
Correct, Your Honor.
And let's read and parse the provisions very carefully before we go into further interpellation. So let us look at Section 25, subparagraph 1. There are two sentences there. The first one is, Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. Correct?
Correct, Your
Very clear. And it says, the appropriations recommended by the President for the operation of government as specified in the budget, correct?
Correct, Your Honor.
Now, Madam Solgen, there is another word, the same word budget, that appears in Article 7, the President, correct? That was Section 22, where it said the President shall propose a budget of expenditures and sources of financing, correct?
Correct, Your Honor.
As part of the NEP, correct?
Correct, Your Honor.
So therefore, here it is clear that whatever is in the NEP should not be increased by Congress.
Your Honor, may I...
You will qualify.
Yes.
Because for you, the unprogrammed funds, no, first, the automatic appropriations are not part of the budget of the President, correct?
That's correct, Your Honor.
And the unprogrammed funds are also not part of the budget, correct?
They are not part of the budget that is... We believe that that is not the part of the budget where the prohibition on increasing the ceiling is applicable.
Okay, I'll take that for now, under advisement. But the point is that, so if you say automatic appropriations is not part of the budget of the President, then I will ask you later to locate it in the Constitution where it is. And the other point is it possible that the unprogrammed funds is not in Section 1, subsection 1, but in subsection 4? A special appropriations bill shall specify the purpose for which it is intended and shall be supported by funds actually available as certified by the National Treasurer or to be raised by a corresponding revenue proposed therein, as suggested by one of our amici, a justice of this court in one recent case, and some of the petitioners, that unprogrammed can be disciplined using subparagraph 4. What is the position of government?
It is the position of government that the special appropriations bill is a separate provision in the Constitution. The Congress has the option. It can be invoked, it can be passed, and historically has been passed. In our study and survey of the different special appropriations bill, the length of time could be as, I think I saw...
We can go to the difficulty of passing a special appropriations bill at some point, and it can be part of the query, I think, of some of the justices. But as far as I'm concerned, I just want to locate where you see automatic appropriation. You say that it is not in subsection 1, and you're asking the court to actually make a ruling for the first time that automatic appropriation is not part of the GAA.
Okay. The automatic appropriations, we say that it is not part of the President's budget because the NEP, which is the President's budget, is presented to the Congress for their approval. However, the automatic appropriations, our premise is that it already has an approval. So we were actually asking the DBM, then why are you including it in the budget, which could be a source of confusion? Because people will just look at the totals, but and their explanation is that for fiscal programming and for transparency, so that it is informing Congress of the total allocation, including the allocations for the automatic appropriation. So in that sense,
it is only for disclosure, in your words, yes. in your comment, in your omnibus comment. It is for disclosure, not for purpose of appropriation, correct?
Yes, Your Honor.
Yes, but there is a purpose for subparagraph 1, and we can go to that later. And whether that squares with your characterization of automatic appropriations is there. And indeed, this court has just ruled in the case of Giao versus PAGCOR, where it actually said that there is an automatic release of PAGCOR funds to, it's Giao versus Philippine Sports Commission from PAGCOR et al. But we will get to that later. In any case, just to flag the different points of view of the parties in relation to unprogrammed appropriations. Now, at issue also is, to a certain extent, presidential certification. I think this was raised by, if I'm not mistaken, the pleading of Pimentel et al., former Senator Pimentel. And what is at issue is the concept of when the president can certify, and flashing to you on the screen, except when the president certifies the necessity of its immediate enactment to meet a public calamity or emergency. So later on, I will ask you, because of the certification, was it possible to ratify the BCC, the Bicameral Committee Conference report, in just the same day that it was distributed? Okay. Just for our information, how thick is the General Appropriations Act? It is a few feet, no, inches.
3 to 4.
Thousands of
4
pages.
volumes.
Yes, and thousands of pages, correct?
Correct.
So they will have the NEP with them, and they will also have the GAA with them, and in between, they have the GAB, they have the Senate version, and they have the Bicameral Conference Committee report, the big one, and the small committee report for 2024 and 25, correct?
Correct.
Yes, so you admit that there was a small committee conference report? Not yet.
I have.
Just so I am very clear that it is in fact there, that there was a bicameral conference committee report and preceded by a small committee report.
I have not seen a small committee report,
Okay.
Your Honor.
Yes, because I asked you and I wanted you to be more deliberate and conscious, just so the transcript will not show that the government has admitted. Okay, now, you know, appropriations is a special kind of law. It is not an ordinary law. This applies to general laws and perhaps also special kinds of law. Appropriations is a special kind of law because first, it originates from the House, Article 6, Section 24. Second, the President has line item veto on this particular law and no other. Third is by the end of the fiscal year, it immediately lapses. Unlike any ordinary general law, it does not immediately lapse. It is reenacted, correct?
Correct.
Yes, and there is, in fact, a position from one of the petitioners, because of the automatic reenactment, what is always the national emergency involved in passing a law? Just so we're clear that we acknowledge that there is that issue and you had your own response, correct?
Correct.
Thank you. May I now ask, I will call on you later, may I now ask on our amici, Professor Solita Collas Monsod, and may I ask her to take the podium this time? Because she has called me out that during her presentation, she lost her opportunity to actually face the court and back because she was sitting down.
Your Honor, may I sit or?
Yeah, please sit down.
Thank
Please
you.
sit down, yes. Thank you, Professor. May I just ask a few basic questions, and I hope my questions are correct. The budget for 2024, 2025, and 2026 is based on deficit spending. And our research shows these figures in terms of the deficits in the program. So for the 2024 program, it was 5.6% of the total budget, total expenditures. In 2025, it was 5.5%, and in 2026, it is 5.3%. Would I be accurate to say that this is the rounded off figures?
I have in my figures 5.7 in 2024, 5.6 in 2025.
Okay, so I stand corrected.
No,
yes.
You may be right.
Yes. Professor, my question is, why is there a deficit budget? Why is it economically sensible to have a budgetary deficit, because the understanding of the ordinary person is you do not spend what you do not have. And therefore, why is it that government produces a deficit?
Well, the government budget is a little different from the household budget. The household budget, the family has to stay within its limits. But in the government budget, considering certain plans, the need for government to stabilize the economy or to do whatever, it needs certain funds and can be allowed to have a deficit as long as over time that deficit is removed and it becomes surplus. In other words, the budget balance is not only for 1 year. It can be, the budget can be balanced over a longer period of time.
And may I ask, that deficit is not something that is arbitrary,
No.
but it is something that is studied by our economic managers.
Absolutely, sir.
And the reason for this is it doesn't want to be irresponsible for the next administrations, and it wants to leave our economic fundamentals intact before it passes to a next generation.
That's right, sir.
Okay. Now, to cover the budget, just so we are clear, there are non-tax revenues and there are taxes as revenues. And if I may just show very briefly and very quickly, non-tax includes fees and charges, not taxes, income from treasury operations. These are interest incomes on our government deposits, like from our land bank. We have advances to GOCCs that are returned, income from our investments, including Maharlika Fund, etc., guarantee fees that are paid to government, foreign exchange risk cover fee, government service income. Am I correct here that these are the income from treasury operations?
Your Honor, you're right.
Yes. And then for national government income, collected by the Bureau of Treasury, shares in dividends, airport terminals, etc. Then we have royalties for our natural resources like Malampaya, and we have foreign grants. Am I correct, Professor, that foreign grants are not treated the same as foreign loans?
They are different. Foreign grants don't have any interest component.
And foreign
Loans,
grants?
You have to pay interest.
Yes, and because foreign grants are almost free.
Gifts.
Gifts, so we receive them, subject only to the political conditionalities or other conditionalities that a donor may give. But does this need to go through the monetary board or our economic managers?
I'm not sure that it has to go. But if it's a grant, it will be
Yes.
definitely accepted.
Yes. Professor, is it correct to say that the more we keep a deficit, the more dangerous it is in terms of our indebtedness?
Oh, it is correct, sir.
And
Your Honor.
therefore, even the deficit that is proposed by our economic managers, and you were one of those key economic managers many times in our government, and you teach this also to our up-and-coming economists, that it is very important that we keep it also to a certain ratio or percentage.
Yes, Your Honor. That's why it's one of the highlight indicators in the Philippine Development Plan.
Yes.
The deficit.
Yes, and would you kindly enlighten us what are the important ratios that we should take into consideration?
Well, the eventual target is to get that deficit down to zero. As I said, the government has is allowed certain leeway, but it must eventually get down to zero. That's why the deficit target of the 2028 budget of the 2023-2028 development plan was to get that deficit down well, originally it was to get the deficit down to 3% of GDP, but in the interim that the plan has been in operation, they have retargeted. Now they want to retarget down to 4.3% of GDP In other words, they realized that their deficit targeting was way below standard, and they had to change the deficit targets, mainly because of this stuff that's going on now.
And in your presentation, you showed us that we missed on several targets, which included the deficit and which included the national debt stock.
Yes,
And would you say that we are at very dangerous times?
Not quite. It's not quite dangerous times. There are certain rules of thumb, and but we're close because, for example, the rule of thumb with respect to debt stock to GDP is that it should not exceed 60%, and we are now at
63.
We are now at 61.
61.
Sus ko, hindi ko mabasa eh. Excuse me. Debt stock. 63. 60.7% in 2024. We're just over that rule of thumb. Rule of thumb that we should keep the debt stock to less than 60% of GDP.
And would you say, Professor, that the interpretation of the court with respect to the words that we find in the Constitution is also as critical for fiscal discipline? In other words, that we should interpret the provisions in the Constitution not only from the original intent of our forefathers, but also from the point of view of what is practical, what the words can bear given the current circumstances and given the creativities of many of the agencies.
I absolutely agree, Your Honor. You yourself said that the Constitution is a living thing.
Yes, and
so it must change and adapt.
And that our legal interpretation also should be also a sort of an economic interpretation, in the sense that we should be fully aware of the opportunity lost and etc.
I fully agree, Your Honor.
Thank you, Professor. Now I am confident that I learned my economics 11 and 101. May I call on former Secretary Butchabad to the stand, please. Secretary, you once were quoted as having called the alarm regarding our debt stock. That 48% of our debt was supposed to be now, 48% of our revenue is now being paid off for our debt, correct?
That's correct, Your Honor.
And since you were DBM Secretary, may I ask, where in the NEP or the BESF do we find the commitments to pay for interest rate on our debt, both domestic and foreign?
It's, well, in the GAA, you can find the allocation for servicing interest. But the amortization of principal, you do not find in the GAA because it's not an interest, it's not an expense. But in the other parts of the GAA.
So that is what I want to clarify, that the payment of the principal cannot be found in the Government Appropriations Act, even if it is something that we use our resources for, but it is not subject to the authorization of the Congress, nor is it made public as to how much our principal costs us for every year.
Yes, because the payment of principal is like a financial transaction. You are just repaying what you borrowed. And like for 2026, as you correctly pointed out, our deficit is 1.5 trillion, but we have to pay principal amortization to the tune of 1.1 trillion. So we have to borrow this year 2.6 trillion to cover the deficit as well as the payment of principal, which, as I said, is a financial transaction not to be found in the GAA.
Okay. Would it be found in the BESF?
I'm not sure. I'm not sure of that, but it's in some parts of the GAA, but not in the expenditures part of the GAAs.
So with respect to the payment of our interest, may I just show you a slide? And this we got from the program amounts of payment in the GAA and BESF, and we contrasted it with the BTR cash operations report, the actuals that were made. And in our study, 2023 and 2024, the actual payment for interest was higher than the program interest. Now, would you know where we get payment for the additional interest because it was higher? Is this in unprogrammed?
No, I think there is a presidential decree 1177 that obligates us to pay above all else our interest obligations as well as our principal amortizations, Your Honor.
So the amount that is put in the GAA can be actually overturned or changed in terms of the actual payment because there is that presidential decree.
Yes, if it comes to that, ahead of any national priorities, those come first. And there are deleterious consequences if we don't do that.
Okay.
Like, for example, the immediate, there's a word for it, that we have to pay all our debts.
Yes.
Once that happens. So we have to make sure that that obligation is settled first. And to make sure that happens automatically, our
Yes.
creditors, in the early days of martial law, insisted with President Marcos
Yes.
that presidential decree should be issued.
Thank you. I go into this just to clarify the effect of whatever decision we make in terms of the planned deficits and its impact on something which I think many of us are concerned about. It is our debt stock and our interest payments. So just bear with me a little bit more, just so we get the actual context. So in terms of principal amortization, we had no other source except the BTR cash operations report. And from our, we did a table, and the table said that in 2023, and I can be corrected here, I'm just looking at the ballpark figures, the principal payment in 2023 was 943.6 billion. In 2024, it was 1.1,257 billion. And in 2025, it was 2025, the preliminary figures is 1.157 trillion in terms of our principal amortization payments. Would you say that these figures are more or less in that ballpark?
Well, the average proportion of debt owed domestically and debt owed abroad is about 80 to 20%.
Yes.
Your Honor.
Yes, but in terms of principal payment, in 2024, we paid 1 trillion in debt payment, correct? And that would have meant for a budget of, let us say, 4 or 5 billion, that was quite a lot.
It is.
Yes.
In fact, that's really, the concern is not so much debt sustainability, Your Honor, but it's really what debt servicing is impacting on fiscal space or the ability to have available funds. Like say, for example, in this instance, we are facing a crisis in the Middle East. We need a lot of funds to be able to support our efforts there, which were not originally planned for. So that if you have a increasing narrowing of your fiscal space, then your ability to respond to contingencies is very much limited, Your Honor.
And going to slide number 33 in my presentation, there is a, if we look at the debt service ratios from 2023 to 2025, and just following what was said a while ago, the debt service ratio, total debt service to revenues in 2023, 41.1%, meaning to say 40% of all our revenues were used to pay for debt service.
That's correct.
2024, it was 45%, and in 2025, it was 45%. That is because we were constantly missing our targets, and therefore our debt service ratio was increasing. And would this mean that 45% of all revenues in 2025 was spent to pay our debt before a single classroom is built?
Yeah, that's not correct, Your Honor. Our inability to use our debts to increase our productive capacity and our very limited revenue generation programs results in much of the revenues we generate are eaten up by the payment of interest and ahead of even the most important priorities that we have to attend to, like public health and basic education, Your Honor.
So this is what you mean, or what the Amici mean, as fiscal discipline, that we need to be able to control the spending vis-a-vis our revenue and vis-a-vis our future because of this particular effect, correct?
That's correct, Your Honor.
And fiscal discipline, therefore, though not yet a part of a constitutional value, what we value now is accountability, transparency, etc. Would you say that it should be one of the targets in terms of a constitutional value to be proclaimed by this court because it has such an important bearing to the interpretation of some of the provisions that will have economic consequences?
That's correct, especially in the ongoing discussion about unprogrammed appropriations. For example, Your Honor, if we take a huge part of the appropriation cover of foreign assisted projects and put them somewhere else, you mean, while you can pay for those use of the appropriation cover for some other projects, well, you can pay for them by cash management. Eventually, you still have to pay borrowings and the increase in deficit that will happen. But these are things that are not known publicly, and in fact, it's good that we're talking about unprogrammed appropriations, especially for the past 3 years when a good part of the program appropriations were diverted for other projects other than what the President put in the national expenditures program, Your Honor.
Thank you, Secretary. The other point that I'd like to make is the debt service ratios, the targets for 2026 was premised on a growth rate, correct?
That's
that
correct.
Growth rate being 6.6%, if I'm not mistaken, correct? But actually now, it might be different given the current circumstances. Is that correct?
That's correct.
And therefore,
Radically.
actually it was 6.5%, and showing to you slide number 35, Okay, we did very basic, and this might be wrong, but a recalculation. So if the BESF of 2026 was 6.5%, if our growth rate becomes 5% or 4%, we saw the figures, the debt to GDP ratio would increase from 62.3, which is the target this year, to something like, if it's a 4% growth rate, it might become 65.1%. Of course, our calculation can always be wrong, but given the lowering of just to show that the lowering of the growth rate will also have an impact on our debt to revenue and debt to GDP ratio, correct?
That's correct, Your Honor.
Then, of course, we have taken into consideration that what we are facing now and the context where we are making a decision right now is a crisis, a fuel crisis. And if we had 3 scenarios, an optimistic scenario where in 2 weeks' time there will be ceasefire, or in 6 months' time, a medium scenario, there will be a ceasefire, or the extreme scenario that the entire year there will be war in the Middle East and continuing with whatever threats were given by the male leaders of the 3 countries that are involved. So showing to you 36, slide 36. It is possible that the cost for every barrel of oil will increase. And then slide 37, macroeconomic impact on the Philippines. And slide 38, it will have indeed a very strong impact on our projections, or the projections right now under the GAA. Would this be a right approach if we wanted to analyze where we are headed?
Well, it's better to see a worst-case scenario and prepare for it, and then if a lesser degree of crisis happens, then you're more or less covered. But our difficulty as a nation, Your Honor, is that this crisis that came upon us as a result of the Middle East war is really more an aggravation over a crisis that has been simmering. In fact, if you recall the statement of the central bank governor, he said, "I've done everything that monetary policy can do to grow our economy, and it's time for reforms in governance and it's time for fiscal reforms and governance to do their share."
So this is an aggravation of an already existing structural crisis, and that the governor of the central bank said that they've done everything that they could with respect to monetary policy. I am tempted to ask Dr. Jokno, except that I cannot, because it will have an impact on our markets if I ask him something about that. But thank you for that. And again, when we did this, just to see our context, we were so thankful that we are only reading the law and the Constitution and not managing our economy. But that we know that whatever we do in interpretation will have an impact on what we need as a country.
I agree, Your Honor.
Thank you, Secretary. May I now... So there is this magnitude of our debt servicing. There is our deficit. Okay. So the question that we want to ask you is, when there is an excess revenue, where should it go first? Legally and constitutionally, or is there no standard? When there is excess revenue, should it go to program, unprogrammed, and because you created a new one, automatic appropriation?
Your Honor, the sources of funds for the program are different from the sources of funds of the unprogrammed appropriations.
But the triggers in the unprogrammed section includes any excess. in non-tax revenues for 2025 and 2026. And in 2024, it was both tax and non-tax revenues. Any excess, it did not qualify.
Yes, yes, Your Honor. For the first trigger, on excess revenue collections in any one of identified non-tax revenue from its corresponding original targets as reflected in the BESF. So meaning, for this first trigger, Your Honor, then the priority will be once it only exceeds the source of financing for the program, then it will trigger for the unprogrammed appropriation.
Sa madalit salita, sinabi natin kanina na may deficit. Ibig sabihin, yung planadong expenditures, pasensya na Ilocano ako pero nagtatagalog ako. So yung gastusin natin ay mas malaki kaysa sa kikitahin natin. Yun yung nakalagay na sa program. Na kahit sa programmed expenses, mas malaki na yung gagastusin natin kaysa yung kikitahin natin. At nakalagay doon sa ating BESF na kapag merong additional na income, hindi maliwanag, sa pakiwari ko, hindi maliwanag kung gagastusin yan muna doon sa program or pwede nang gastusin palagi doon sa, or pwede nang gastusin doon sa unprogram. Hindi naman palagi, pero pwede nang gastusin sa program. In other words, my question is there anything in statute or in the Constitution which compels in the budget execution that whenever there is excess income, and I will now go to excess income in non-tax revenues, because that is the trigger in 25 and 26, that it should first be spent for program before unprogram?
It is only in the GAA, Your Honor.
So, in other words, there is no constitutional frame where it says, finish the unprogram first before you can go to the unprogram, except the case of Araulio, but it in a general sense, and I would even submit a bit of obiter, correct?
Correct, Your Honor. But the Araulio, based on our position, is premised on a different GAA, and the articulation of the triggers in the Araulio case are different from the articulation of the triggers in the 2024, 2025 to 2026 GAAs. And also in the Araulio case, there was a subsequent motion for reconsideration that was filed, and it actually clarified that you don't have to wait for the whole year to ascertain whether there was excess, because otherwise then there will never be funding for the unprogrammed appropriation. So in the motion for reconsideration, the court clarified that based on a quarterly report by the DBM, there can be a determination of whether the target has been met.
Okay, just to be clear, I will flash now the triggers in the unprogrammed funds. Okay, 2024 was quite unique. There was a subparagraph D. And subparagraph D is now non-existent. It is null and void. It was stricken down in the PhilHealth case. Okay, so we are left with the first trigger. And the first trigger, if you notice, it says coming from the excess revenue. I have to look at my copy because I cannot also see. Okay, so the first trigger is excess revenue collection in or any one of the identified non-tax revenue sources from the corresponding revenue. If you compare it with letter A of 2025, same. Compare with letter with 2026. Identified non-tax revenue sources from its corresponding revenue collection targets as reflected in the BESF. Then in the letter B, new revenue collections or those arising from new taxes or non-tax sources. Also letter B, also letter B of 2026. Approved loans, the difference is letter D. It does not exist, correct?
Correct.
Do you notice any other differences? In 2025 and 2026, excess revenue collections in total revenues was removed. Correct?
Correct, Your Honor.
As well as fund balance of GOCC.
Correct,
Yes.
Your Honor.
This is the only provision in the GAA which controls where excess revenues, new tax sources are to be spent. Correct?
Correct, Your Honor.
So there is nothing in the GAA which allows the DBM and the President to allow a SARO to be used immediately to pay for unprogrammed appropriations. Correct? In other words, when there is excess revenue, nakalagay dito excess revenue. So pwedeng gamitin na kaagad sa unprogrammed appropriations. Tama?
Correct, Your Honor.
So, ibig sabihin, the category of programmed and unprogrammed is really, does not really have a material difference. Because in the interpretation of government, pwede kapag merong excess na pera, excess na revenue, na hindi naka-earmark, na pwedeng gamitin na ito kaagad sa unprogrammed funds. Tama?
Tama po, Your Honor.
And that was why Senator Drilon was actually proposing that we have to be clearer. And actually also Secretary Butch was also saying that, and of course Secretary Jokno was also saying, you have to discipline all of this so that it's very clear that it should be in program funds, correct? And constitutionally, it matters because once you transfer a PAP, a program and project and program, coming from program funds, okay, and you transfer it to unprogrammed funds, and you want to fund it immediately, you can increase the amount of unprogrammed funds, like in 2024, you can transfer funds there so that it continuously increase, and the fiscal space created in the program funds, you can reallocate. And then you can have the chance of still having it funded. And in the interpretation of government, you do not violate 25(1) because to you, the limit is the program. Correct?
Correct, Your Honor, because again, in the analogy that we attempted to include, that we attempted to make in regard to programmed and unprogrammed, is in number one, the prioritization of the programs. So if you put a PAP, a project...
Madam Solgen, how do you say that it's a priority? So we have deficit. Ibig sabihin, mas malaki yung gagastusin natin kaysa yung nakukuha na kinikita natin. Pero kapag lumaki yung kita natin, what you're saying is, there is nothing in the GAA, and I do not see anything in the GAA, which says you have to fund the program first before you go to unprogram. Is there?
Okay. Yung pong, kaya ko po sinasabi na priority, sapagkat yung sa NEP pa lang, ikinocommit na po ng executive na kung ako ay magtatrabaho at ganito ang mga economic factors, kinocommit ko na meron akong kikitain ng, let's say, 1 billion pesos. Priority po yun sapagkat kinomit na ni executive. Kaya yung mga nakalista doon, pagka na-meet na po yung targets, then they will finance the program. So, the fact that it is put in the unprogrammed...
To be clearer, Madam Solgen, the program funds has expenditures, correct?
Correct po.
The revenue to cover these expenditures are lower than the program funds, correct?
Correct po.
So in other words, there is a deficit, may kulang. Tama?
Tama po.
And sinasabi ng pamahalaan natin, kikitahin namin to. Sana lumaki yung income namin. Sana, magkaroon ng dividendo sa PhilHealth or whatever, or some GOCC na umakyat to. Okay. But here in the provision in unprogrammed fund, it says, excess revenue of non-tax sources can be used for unprogrammed funds immediately. There is no control. There is nothing here that says you have to spend first in program. There is no footnote, and we searched the GAA as best as we could, and perhaps you can ask your own staff to take a look at it. There seems to be nothing which says there is an excess. You have to spend it first for the program. That's why I'm saying, even if in terms of symbolism, program seems to be the priority of the president, when Congress puts it in unprogrammed, there is a possibility that there can be a SARO to be issued in order to release funds for the unprogrammed funds, correct?
Your Honor, our interpretation of the total revenues here are the total revenues that have been set as the target.
Yes, ganun pa rin. Ibig sabihin, yung tinarget na income and targeted expenditures, may deficit pa rin. May pagkukulang yung kikitahin batay sa BESF mismo. And I asked two of the experts already, and in fact the presentations, there is a program deficit. And the program deficit will be funded by non-tax sources and debts. Pero ang sinasabi ko ngayon, nasaan dito sa GAA natin yung provision na nagsasabi, pag meron kang bagong kita, gamitin mo muna sa program. Is there in the law, in the GAA law? And my next question is, should it be in the reading of our Constitution that that cannot be done? That when the government commits program funds, that it cannot use whatever it earns immediately for unprogrammed, because your concept of unprogrammed is standby. Ano hong ibig sabihin ng standby? May mauuna sa kanya. Ibig sabihin, halimbawa sa isang pamilya, sasabihin na mauunang kakain yung mga maliliit na bata kung kulang yung pagkain natin. Therefore, yung mga matatanda naka-standby. Hindi sila yung mauuna. So, my next question is, was there any expenditure in 2024, 2025, where the unprogrammed came before the program funds?
I would, may I confer with my team,
Yes.
Your Honor?
Meron, di ba?
Yes, Your Honor. My team confirms that.
I am confident about that because that was presented to us during the PhilHealth oral arguments. That there were expenditures that came first from the unprogrammed rather than the program. Okay, now, before you spend for unprogrammed, there has to be excess, correct?
Correct, Your Honor.
And therefore, by the way, what is a SARO? What does SARO mean? Just so we are clear about the abbreviations that we are using. Special allotment
po.
release order, correct?
Special allotment release order.
So it is an order coming from DBM to the Treasury to release money, correct?
Correct, Your Honor.
Yes. Now, for every SARO coming for an unprogrammed item, must there be a certification of excess income?
Yes, there must be a certification of the presence of A, B, or C.
Okay. Because, can you assure this court that every expenditure in 24 and 25, because that is at issue now, has come from a certification accompanying a SARO?
That's theoretically the case,
Okay.
Your Honor.
So, can I ask the government to submit to the court copies, a listing of all the SAROs from the authorizing release from the unprogrammed, as detailed as possible, meaning to say not the cumulative, but all the SAROs, you can list it down and give us digital copies. And for each of the SAROs, please match it or correspond it to a certificate of income or whatever the treasury issues, certification of excess income or 1, 2, or 3.
We will comply, Your Honor.
Can you comply by next week so that the justices who will interpolate can have that as a resource also?
We
Correct?
will comply, Your
But
Honor.
as far as we are concerned right now, you admit that there is nothing in the law or in the Constitution that says that whenever there is excess income, the budget execution is compelled to first do program.
Okay. May I clarify, Your Honor? So again, because in my understanding of the supporting financial sources, because they are defined and they are not commingled. So meaning if the sources of funds for the program are A, B, C, D, the sources of funds for the unprogrammed are E, F, G, or maybe A plus 1 in terms of the first. And so that's why, to me, there should be no other requirement to be found in a law or in any provision in the GAA because the sources are different.
Okay. You say that it's specific. But if you look at 2024 trigger, it actually says excess revenue collections in the total revenues. Meaning to say, basta't excess dun sa total. Okay? Or in any one of the identified non-tax revenue sources from its corresponding revenue collection as reflected in 2024. Noong 2025 and 2026, they removed the total and they just put there excess revenue in any one of the identified non-tax revenue sources. Meaning to say, for the identified non-tax revenue sources, it was almost earmarked. Kapag may increase, any increases there was already earmarked for unprogrammed.
Correct, Your Honor.
So you are earmarking funds that are excess, meaning to say good collections of government, good performance of a GOCC, you have earmarked that for unprogrammed, not for the program.
Correct, Your Honor.
And yet
Which
you
is-
say, the position of government is that Congress cannot exceed the ceiling of the President's budget, but it can exceed the unprogrammed, correct?
Yes, Your Honor.
That's why it was 303 billion pesos, correct? Exceeding.
Correct, Your Honor.
So if I were a member of the House, and I will not certainly become a member because I cannot win any election, but if I were a member of the House, bakit ko ilalagay sa program? Ilalagay ko na lang sa unprogram. Sigurado pa yan, kapag may excess revenue, mauuna ako, hindi yung program. And I can put anything in unprogram so long as the leadership or the BICAM will accept. That's why it was a jump of about 400 billion from the agreements of the House and the Senate, and then bicameral increase it by 400. I would rather go there because I can add everything that I want in the unprogram. So goodbye fiscal discipline.
Your Honor.
Yes. Where did I make a mistake?
Okay. In assuming that the executive or the Congress, actually, it's like everyone has is gaming the mechanism. It's as if we are thinking that why would the Congress not put the priority programs in the unprogrammed appropriations because that will for sure be funded, which is incorrect. Because if the government...
You have asked a question that I will ask from someone coming from Congress. Why would they choose unprogrammed from program? Or why is it that they would rather move some of the program to the unprogrammed? So it creates fiscal space in the program because there is a limit, correct? And
Correct.
therefore, they can make inclusions. I'm trying to avoid the word. Inclusions, insertions, etc. into the program. That's a theoretical possibility. I'm not saying that that happened. But what I'm saying is you create the fiscal space and then you move it to, by moving it to unprogrammed, and then you can put whatever you want in the program. Okay, that's one possibility. Okay, now, of course, we do not assume the worst. But then it is our role to actually put the guardrails so that this will not happen. And therefore, to prove that I am wrong, therefore, that is why I'm requiring, were there expenditures from the unprogrammed that came before expenditures from the program? Second, were there expenditures from the unprogrammed that did not have the, what do you call it, the certificate of excess coming from the, no less than the treasury, because it is the only one that can determine whether there is excess income, correct?
Correct, Your Honor.
Okay, so we will require that of you. By the way, how do you get a SARO? A special allotment release order. There is the regular releases. And the chief, for myself under the SET, si Chief Ben under the HRET, we have that authority. Once in a while when I am acting chief, I issue a release order for benefits of the staff, always. But in any case, that's the point. There's a regular release order, correct? Special allotment release orders are special, correct?
Correct, Your Honor.
Who releases that?
The note here says, please ask DBM. Well, DBM is the...
DBM, okay. And before the DBM releases, this is the President's budget, correct?
Correct, Your Honor.
Must the DBM always clear with the Office of the President that it will release a special allotment release order? You see, the DBM is part of an economic management team, correct?
Correct.
And therefore, they have to make sure, as you said in your opening statement, they have to make sure that the funding is within their entire plan. They have a Philippine Development Plan, correct?
Correct, Your
So
Honor.
is it the practice that the DBM issues it, this SARO, because it wants to?
Okay, I've gotten information. Some secretaries said that they need the president, and some say that it's within the power of the Secretary of DBM.
Okay, for this administration. Just so we know, because we are about to come to a ruling with respect to how it is. And if it is only an alter ego lang pala nagre-release ng SARO, then that will weigh heavily on us. Because at least if it's the president, we will know that we are dealing with a co-equal entity. And the president, of course, comes with a lot of respect in this courtroom.
For the current secretary, in our briefing, he said that he confers with the president.
Okay, for every SARO, therefore, that is also with the consent of the president.
It should be.
Okay, and of course, you're going to give us the SARO. Are SAROs only for unprogrammed funds?
I don't think so, Your Honor.
Yes. Anyway, please cover the process of the SARO also in your memoranda, because that is very important for us to be able to identify. Okay, thank you, Madam Solgen. May I ask Dr. Jokno?
Thank you, Your Honor, for now.
Okay. Madam Solgen, just to be clear, for every SARO, there needs to be consent by the President.
Based on what Secretary Rolly told us, that for the release in the unprogrammed appropriations, he has to get the alignment of the President.
And for the budget secretary before the current budget secretary?
I do not have that information now, Your Honor.
Okay, thank you. Please be ready because I am sure the next interpellator after me will ask you again.
Yes, we will prepare, Your Honor.
Yes. Good afternoon, Dr. Jokno.
Good afternoon.
During your time as DBM Secretary, did you need the permission of the President to release any SARO?
Yes, because SARO, it does not apply only to ADAN program allocations. It applies also to some special funds like calamity fund, contingent fund, and miscellaneous personal benefits fund. That you need the approval of the President. But may I answer the previous question?
Yes, yes.
Okay. I researched and I found out that there usually Congress would increase the appropriation of certain departments like Public Works, and they will reduce the allocation for DOTR, right? So he cannot veto that increase. Otherwise, the whole budget will be
affected,
right?
Yes, because...
So, but he has a general instruction that he will say, I have found, it is interesting that the Congress has increased the allocations for certain departments. Now, my instruction is this, okay? I'm just paraphrasing the veto message, that they should submit a special budget to DBM, coming up with a revised performance targets, and it has to be consistent with our cash programming and other rules and procedures, and approval of the President. There's always approval of the President, except in 2024, that I noticed. Okay.
Thank you for that very enlightening.
But I will put that as part of my brief.
Thank you. Can I just ask some contextual questions? So this concept of unprogrammed funds, in your experience and your research, when did it actually start?
Well, I have not looked at us way back in 2019. As I said, I prepared the when was EDSA one? 1986, right?
1986.
I prepared the 1987 budget. That's the first and only budget under the Freedom Constitution. And I already used the unprogrammed appropriations at that time. And it has been used ever since.
And back then, did you have triggers for unprogrammed?
Yeah, actually it was primarily meant for foreign assisted projects.
Only foreign assisted projects?
That was the main reason for the unprogrammed appropriation. There's also an entry, if I remember right, called General Fund Adjustment. So for example, there's a pending case that is finally decided by the Supreme Court after 20 years, and there's an instruction from the Supreme Court to that agency to pay this guy or this contractor. We get the money from that General Fund Adjustment.
Yes.
Unprogrammed.
Yes. But nowadays, Dr. Jokno, the Supreme Court does not need 20 years to decide. It is now much less.
But it's not your turn.
Yeah, yes, no, not 10 even. But the point is that it was there as a standby fund for things like foreign assisted projects. So in your opinion, today, it is still important to have unprogrammed funds?
Definitely, Your Honor, because as I said, any project delays is costly. For example, they remove funding for the subway system that's supposed to be finished by 2029, right-of-way appropriation for the subway, and also the north-south rail system they remove, and they put it under unprogrammed. That will cost a delay of at least 5 years in the implementation of that project. At the same time, because it's delayed, then we have to pay what is called commitment fee to the lending agency, and that's usually around quarter of 1%.
Uh, just to be clear, so you are saying that the funding for the subway was moved from the program to the unprogram?
Well, I have some numbers there. I will put that in my brief.
Yes. So in other words, in 2024, 2025,
Several years.
for several years, the funding that was supposed to be for the payment of the subway was moved from the program to the unprogram.
Or it's deleted from the program.
Deleted from the
I
program,
don't know whether that was put under the program.
and then in the unprogram, it was subsumed under, or the understanding was, it was subsumed under foreign assisted projects?
Correct.
Yes. And you are saying that that meant that instead of the unprogram being assisting us in the sense that you have a standby allocation so that when it is already ready, that we can make the initial payments already. What happened with the subway was we had to spend more because there was no allocation to pay the counterpart.
It cannot move forward because there's no funding for right-of-way acquisition.
Okay. And you mentioned another project. What
the
was it?
North-South rail system.
These are the big ticket items.
The railway system that will go all the way to Clark and go all the way to Laguna.
So these are big ticket items that was
Yes.
supposed to be already funded, were these major projects of the current president?
Yes.
Yes, these were.
This was done to create what you say fiscal space, so that the congressmen and the senators will have their own projects funded under program appropriation.
So just to repeat what you said, and this is not my words. So this was deleted, these two projects, big ticket items.
The budget for the right-of-way was
Budget
deleted.
for the right-of-way for the purpose of creating fiscal space.
I have the numbers.
Yes, thank you.
Okay, these are general adjustments. The budget of the Department of Transportation for year 2022 was reduced by 49.9%, from 151 billion to 75 billion. For 2023, it was reduced by 36.6%, from 167 billion to 105 billion. In 2024, it was reduced by 65.5%, from 214 billion to 73 billion. And in 2025, it was reduced by 51.4%, from 180.9 billion to 88 billion. This is for the Department of Transportation and Communication, which is responsible for the big ticket items, the big projects. At the same time, the budget of the Department of Public Works was adjusted from 38.6 billion to 786 billion in 2022, then, or by 14.6%. Public Works, okay. And then in 2023, it was adjusted from 718 billion to 894 billion, or by 24.5%. And then in 2024, from 822 billion to 997 billion, or by 21.4%. And in 2025, from 900 billion to 1.1 trillion pesos, or by 21%. Okay.
Thank you for the data, Dr. Jokno. My next question is, unprogrammed, why would anyone choose to put an existing PAP, project or program, already in the regular budget, in the regular program budget, why would they want to transfer it to the unprogram?
Let me, that's the same question you asked the previous.
Yes.
The procedure is like this. Sometime under President Ramos, I was sitting as a representative of Senator Angara in the LEDAC, and it occurred to me that the budget system is so cumbersome. For example, you prepare the budget first half of the year, give it to Congress, and then after it's passed by Congress, nobody can spend the money because they need an SARO or a GARO, okay? They still need that. And I said, what the hell? But why not use the General Appropriations Act as the release document, which we adopted, okay? So now, we're now only talking of the SARO, no longer the GARO, meaning that the budget is, as approved by Congress, can be implemented from day one because you don't need a GARO anymore, okay? Now, it's only with respect to the SARO. So it's not going to happen that the unprogrammed, the items in the unprogrammed appropriations will get first priority before those in the regular budget. Because, as I said, from day one, you can already spend your budget on the basis of that reform which I did during the Estrada administration.
So even if there are excess funds, it is a matter of who uses it first.
Correct. So you have a long list. I noticed the long list, around 300 billion worth of projects. Now it depends on the Secretary of Budget. But if with respect to the foreign assisted projects, their priority is to fund the implementation of the foreign assisted projects. That's their priority. Once the loan agreement is completed and the funds released, then it goes through. And then in answer to the previous question about grants, all money, even with grants, they have to pass through the Treasury first. And the Treasury has to acknowledge that they received something. And then the agency who is the beneficiary of the grant will submit a special budget to DBM, and then they can use the money. That's, in that sense, the grant is what is called automatically appropriated.
Okay. Thank you. The other point that you made during your opening statement was the increase in the allotment of the road users fund. Okay. Can you enlighten the court why there is a push usually to increase the road users fund apart from what is provided in the NEP?
As I said, that road users fund has been a major source of corruption during somebody else's term, right? But the point is that that allocation is submitted by the Secretary of Public Works to the President and the budget. And it is based on a formula, like, for example, the linear, the length of the roads, the quality of the roads, how often should it be maintained, etc., and the capacity of the agency. So to me, that is a very solid estimate of the Secretary of Public Works. It used to be prepared by the Road Users Board, which has been abolished as a result of the recent law. So the Secretary of Public Works will submit that to the President, and then DBM will then take into account what was submitted. So what you saw there is what they submitted to the President. And so I don't see any reason why Congress will insist on increasing the allocation.
And in fact, in the 2025 budget, the veto message of the President was they understood that the road users tax, without vetoing, I think, they said they understood that the amounts that they presented will only be what is expended.
Correct.
Although not clearly vetoing the increase in the road users tax. In any case, thank you, Dr. Jokno, for very enlightening points. Sige, Chief. Para makapahinga tayo.
Sa next session,
Yes. Before the chief is intending to adjourn, but may I just ask the Solicitor General? So kindly also prepare information about the usage of the road users tax in 24 as well as in 25.
Yes, Your Honor.
Yes, for submission to the court, all of the requests during this interpellation, kindly submit before noontime of Wednesday next week. Before noontime of Wednesday, so that you have Tuesday next week para 1 week na total. Would that be okay, Chief? Yes.
We will comply, Your Honor.
Solgen, for the next oral argument, can you bring with you the DBM representative to the DBCC, as well as the DepDev representative sa ICC? Can you bring them with you as resource persons? Because my line of questioning has questions for them.
Okay.
Thank
Yes,
you.
Your Honor. We will
Thank you.
comply.
Thank you.
Thank you.
Investment Coordination Committee.
Before the court is a motion for leave to nominate amicus curiae filed by the Council for Respondents, the Solicitor General, requesting that former Representative Jose Maria Clemente Joey S. Salceda to be included as an amicus of the court.
Yes, Your Honor.
Okay, the same is hereby granted. Former Representative Jose Maria Clemente Joey S. Salceda is invited as an amicus for these proceedings. Please request him to coordinate with the Office of Senior Associate Justice Marvic Leonen for his presentation in the next session.
Thank you,
Thank
Your
you.
Honor. Thank you.
Lala. Madam Clerk of Court, are there any other matters?
There are no other matters, Your Honor.
There being no other matters, this session is suspended to resume on April 21 at 9:30 in the morning also. Thank you very much.